Good morning. If you would please rise and join me in saying the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And with that, I am opening the public hearing on House Bill 1713 and invite the sponsor to introduce the bill.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Steve Shurtleff, and I represent Merrimack District 15, which is Ward 1 of Concord, the village of Pennacook. And I'm here this morning, Mr. Chairman, to introduce to this committee House Bill 1713, which would make it a offense for a person charged with a Class A felony or greater to fail to appear for a trial or any part of the criminal justice process. Mr. Chairman, I retired from the U.S. Department of Justice, and under Rule 42 of the Federal Rules of Criminal Procedure, the rule is that anyone charged with a felony in the federal court system must appear at all aspects of the criminal justice process, from their initial appearance, arraignment, jury selection, trial, and if found guilty, be there for sentencing as well. That's for all felonies. What this bill would do would limit it to a Class A or greater felony. The rule I just mentioned, I thought the state of New Hampshire would have a similar rule or a similar law to what the federal government had. And it wasn't until last month that I realized that I was mistaken about that. On December 7th, 2019, 5-year-old Harmony Montgomery was brutally beaten to death. And after an extensive investigation, her father was charged with that murder. His trial lasted 12 days, and for most of those 12 days of jury trial, Adam Montgomery decided he didn't want to be there. The jury finally came in with a verdict. Some of the counts they found him guilty of were second-degree murder, second-degree assault, falsification of evidence, and abuse of a corpse. Even when the jury came in with their verdict, again, Adam Montgomery decided not to be there. The judge set the sentencing date for Adam Montgomery for May 9th. And it's my understanding that Adam Montgomery has already indicated he did not plan to be there for the sentencing as well. And the county prosecutor has already filed a petition with the court asking that the court issue an order mandating that he be present for the sentencing. As I said earlier, what this bill would do, anybody charged with a Class A felony, which is a felony, as most of you know, with a period of imprisonment from 7.5 to 15 years, or any crime with a greater period of incarceration, and that would include murder, felonious sexual assault, armed robbery, kidnapping, and several other offenses. I'm going to close there, but just add one more thing, Mr. Chairman. When the prosecutor filed his motion with the trial judge asking for that order to have Adam Montgomery in court, he said in his motion, and I paraphrase, that Harmony Montgomery's family and loved ones will be in court that day. Adam Montgomery should be there as well to hear from the court directly what his sentence will be. And when I hear that phrase, Harmony Montgomery's loved ones, I feel that that includes all of us too, the citizens of New Hampshire. And I'd be glad to answer any questions, Mr. Chairman.
Thank you, Mr. Speaker. Questions for Representative Glenn?
Thank you, Mr. Chair, and thank you for taking my question. I very much appreciate and support the intent of the bill. I wonder about, for example, in a case, as you mentioned, of felonious sexual assault, for a victim who's testifying, having to have their alleged assailant staring at them while they testify, whether there might be, like, I'm just trying to think of it might be more uncomfortable to testify with their alleged assailant staring at them. And I'm just wondering how to balance that with the need to make sure the person is present. And I know I'm not phrasing that well, but I hope you understand.
No, I know exactly what you're saying. Although under Article 6 of the U.S. Constitution, every accused person has a right to face their accuser. I don't know if a motion could be filed with the court by the prosecutor, maybe having them testify by closed circuit television from an adjoining room, or to make some accommodation to make it easier for the victim, especially if the victim is a minor. I think would be even more traumatizing to that person. But I'm sure this has come up before in the court. And again, the defense could argue the Article 6, but I think accommodations could be made. Thank you for that question.
Just to answer your quick, accommodations are made, especially where a defendant is disruptive or threatening, staring, doing something to the victim. The courts do make accommodations, as all the way from removing them to having them sit somewhere else. They're very creative when they need to be. Further questions? Representative Newman.
I have just two questions, and they're just mainly about the process, so I understand what the process is. And on page 1, line 9, it says, upon the motion of the defendant, the court may excuse the presence of the defendant required by paragraph 1 for good cause. And I'm just wondering, does the judge make the decision then? Is that what they mean, good cause? How does that work?
Exactly. I could see a person out on bail for a Class A felony and having a sickness in the family, having a dying relative, or something really catastrophic happening in their life, where the defense attorney would want to make a motion to the trial judge asking that they allow the defendant to be excused for whatever, that's why I put in the words just cause, whether it be a funeral or whatever it might be, that could be allowed.
Follow-up? And the follow-up is on page, I guess it's the last page. And it says the term of imprisonment pursuant to this section shall be consecutive to the sentence of imprisonment for any other offense. So my understanding of that would be that he would have reached all of the requirements for the offense. And then if he had not shown up sometime previously and there was a consequence to that, that consequence would be consecutive to that previous term of imprisonment and would follow on after that.
Exactly. For example, someone out on bail for a Class 8 felony, a serious felony, and jumps bail and takes off, which has happened before. If they do that and they're found guilty on their underlying offense, the fleeing would be an additional sentence on top, on and after the original sentence.
Could I ask one more follow-up for it? Okay. But this, in this section specifically has penalties when the person refuses to show up for court, even though they're ordered to, and all of that. I believe there are penalties for that, because it says pursuant to this section shall be conservative, and that wouldn't be jumping bail. That would be, he would finish up everything, and then there would be, if he hadn't shown up, it would be after that. Is that right? Or
well, what it is if a person is scheduled to be in court and would be released on bail, I know in the federal court it's failure to appear is what the offense is. If they do not come to their trial, actually once the trial begins and a person should jump bail, the trial could go on in absentia without them being present because they voluntarily absented themselves from the trial process. They would finish with the court and there'd be a ruling. If they're found guilty, they may be not captured or not found for years after. When they say after they finish their original sentence for what they were charged, there'd be the additional penalty, which could be up to the maximum under a Class A felony.
Thank you.
But that again would be discretionary with the court.
Thank you.
Representative Bolden.
Thanks for taking my question. Is it the case currently that the court can, or rather that the prosecution can request that the court order the presence of the defendant?
Yeah, I'm this back here so I can look at me. I looked through the New Hampshire rules of criminal proceedings, and I looked through New Hampshire state law, and our House counsel did as well. And there's really no requirement for a person to be at their own trial. I was talking to our Merrimack County Sheriff the other day, and he told me the same thing. Often, a deputy would go to pick up somebody in the county jail, and the person will say, "No, I don't want to go today." Okay, and that's it.
Follow up.
But thanks for taking my follow-up. But is it currently possible within the rules in the court system in New Hampshire for the prosecution to motion to compel the presence of the defendant?
No, there's no rule or law that says that a judge can mandate that a person be in court. I suppose they could issue a subpoena for them, or if it was a question of identification under those circumstances. And I'm sure that'd be a motion by the prosecution, and the judge could grant that motion and have the person, but to say, I just want to have him in court without any particular reason, then no. But
In the instant case, though, in the Montgomery case, the prosecution has filed a motion to compel him to appear. Do you know under what grounds they're using to file that motion?
No, I just know that what I read it briefly online some time ago, and the prosecutor had just said that they felt it was in the best interest of the family and loved ones that they be in court to hear the impact statements and everything else and not be excused. So, and that's a kind of a good example to your question too. The fact that the prosecutor has to file a motion to get Adam Montgomery in court for his own sentencing, and now it's up to the judge to make that determination.
So just to be clear, a prosecutor can file a motion for anything, but there's no law that would compel the judge to actually do it. So I think that's the answer to that. Representative Stone.
Thank you, and thank you for taking my question. I think you've actually partially answered it, that this impact would allow, if passed, the victim to face the victim's family, the accused, and that the impact statements be read and they'd be basically held accountable in public, in person, versus taking a cowardly way out by avoiding to go to their trial when faced with heinous crimes.
Exactly. In the case we're talking about with Adam Montgomery, if the judge should deny the prosecutor's motion to have him compelled to be there, a victim impact statement would be read, but it'd be read to an empty chair at the defense table.
Thank you.
Thank you for your question.
Representative Muse.
Thank you for taking my question. On line 23 of the bill, it says a person is guilty of a Class A felony if having been charged or awaiting sentence for an offense punishable by life imprisonment or imprisonment of a maximum term of 15 years or more. The language in the bill, having been charged or awaiting sentencing, seems to open the door to the possibility that someone could actually be found not guilty of the crime, but still would be charged with an offense if they didn't appear for some reason. I guess my question to you is does that concern you, and is it something that you think we need to address in the bill?
It's something you may want to look at, but it doesn't concern me. It quite simply says that if you're charged with a Class A felony, you must make all court appearances. And that's why I put the provision in the bill. If a defendant's attorney makes a motion to the court saying, I'd like to have my client excused from this court hearing, and this is the good reason I have for doing it, then the court would grant that motion and everything would be fine. Normally, if somebody does not show up at a court hearing, they normally have taken off. There's always extenuating circumstances that somebody could argue. But if it was simply they did not want to face their accusers, they did not want to have their day in court, then that's a separate matter. But there is a mechanism to excuse that person from court if they wish to absent themselves. But thank you for that question.
Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. I'm curious, and we might have somebody who's coming to speak from the Judicial Department. I know that it says that they were consulted in the writing of this bill, and I'm just wondering if there is the process of petitioning the court to have them compelled to appear. Do you know what are the metrics by which that decision is made?
Well, that's a good question. I thank you for it. Under the current circumstances with Adam Montgomery, the prosecutor has done the only thing that he can do, and that is to petition the judge, asking him to compel now the convicted person to appear for their sentencing. That is the only mechanism available, is to ask the court to mandate, and the judge may very well order that person to appear at sentencing. But then again, they've got to base it on law and precedent of the court, and I don't know what grounds the judge could give for saying, yeah, they need to be there, other than humanitarian reasons that I think we all see.
Representative Bolden.
Thanks for taking another question for me. It seems like it wasn't helpful in the case they've been referencing that the defendant wasn't present, that it wasn't helpful to the defendant's case. And I wonder, do you have any thoughts as to the pros and cons of essentially legally permitting someone to hamstring themselves versus requiring them to appear and potentially losing the impact of their absence?
It's my understanding in this trial that the judge, in his charge to the jury, told the jury, please take no inference in the fact that the defendant has not been present. And again, I refer to that one part of the bill that does allow defense attorney to file a motion with the court, and they may not want their client, and I suppose the defense attorney could argue in that motion. I feel it would unduly influence the jury to have my client present, and the court may grant that motion. But then again, it'd be up to the court.
I think we have to be careful not to confuse the person's Fifth Amendment right not to incriminate themselves. In other words, not take the stand, versus the mere fact of them being present in the room for the purposes of having to face their alleged victim, versus taking an inference from them not testifying. It's a different but close situation. Further questions?
I would just add to that, Mr. Chairman, that's an excellent point. I spent almost 30 years in the federal court system, and I can't recall any time an attorney didn't want their client to be present with them in court. And of course, they're not just dressed in their orange jumpsuits. They have them in civilian clothes. The jury never sees them in handcuffs or any other restraints. So not to prejudice that jury.
Absolutely. Seeing no further questions, thank you for
Thank you,
introducing
Mr.
the bills
Chairman.
forward,
Thank
Mr.
the committee.
Speaker. Anyone else? Is anyone else wishing to testify on this bill who has not done so or signed up to do so? Seeing none, I hereby close the public hearing. And we are going to take a 5-minute recess so that we can quickly caucus with our parties and then come back in and exec this bill. I am opening the executive session on House Bill 1713 FN, and I am recognizing myself to make a motion, and I move ought to pass. May I have a second?
I'll second that.
Did Representative
Kevin
Gathright?
Pratt.
Yes.
Representative Gathright is going to second. Thank you, though. Seconded by Representative Gathright. And I will speak to my motion. As we've all aware of the case that spurred this bill, it's horrific, and for that family to not be able to face the person who did this is, I think, a re-victimization of them twice over. Having said that, we don't legislate based on one case. But what one case can do is illuminate for us an existing problem. And the fact that we have, I would say, conflicting laws. On one hand, we passed a law that says victims can have a victim witness impact statement where they can tell the court the damage the perpetrator did to them. And also, many times the letter is to the perpetrator saying, this is what you did to me and my family, and I hope you don't forget that. At the same time, letting the defendant basically say, I don't care, and not show up, really makes the first one worthless. What good is telling or writing an impact statement to a perpetrator if he doesn't have to hear it? So based on that, I think that it is imperative that we make sure that people that commit these crimes face up to what they have done, and it, not only for themselves and the victims, but for the public at large to see that justice, there's a penalty for breaking the law, and you will have to face it. Also, I would point out that there are safety valves built into this legislation where a judge will have discretion in certain circumstances to say this person doesn't have to be here for various reasons. The prosecutor can even use that to say, we don't want this person here for various reasons, be it intimidation of witnesses or the jury or what have you. So there are mechanisms in this law, as I said, that are safety valves. So I would urge you to support this and vote ought to pass. Representative Harry Gathright, would you like to speak to your second?
Yes. I truly believe this is a good bill, but I did have somewhat of a concern that a person would be punished even though they weren't found guilty yet. So I think for me, I like the idea more so that the person has to be there for sentencing. But I'm going to vote for this bill because I believe that it's at least trending in the correct way for someone that refuses to show up in their court appearance.
Thank you. Further discussion. Representative Selig.
Thank you. Like Representative Harriet Gathright, I too like the intent of the bill. I understand it. It makes sense to me. But I have concerns also that it has to be a consecutive sentencing and that it doesn't give the judge leeway or flexibility. I feel like our judicial system is designed to allow our judges to use their best discretion in sentencing, and that's an aspect that concerns me. So I'll be voting in support of the bill, but I am hoping that there will be essentially a floor amendment to address that, and perhaps also maybe make it that they have to be there for victim statements and sentencing, but not necessarily mandated for the rest of it if that's truly their choice.
Thank you. Representative Stone.
Thank you, Mr. Chairman. And I think this bill is a necessary tool that the judges can employ if it passes into law. In addition, I think we have a history in this country of having public trials for a reason, and that includes having the defendant and victims both at the trial to be heard in public. We don't really have closed criminal proceedings. Therefore, I think it's more appropriate to have a defendant at a trial, especially to hear the impact on the victim's family or from the victims themselves. I think a lot of times in this committee, we seem to focus more on the defendants and not enough on the victims and the impact that they have or their families if they are no longer to have the ability to hear it for themselves.
Thank you. I just wanted to add something in response to what Representative Selig made. She made a good point with regard to discretion for the judge. And I would point out that this still remains. There's not a minimum mandatory sentence applied to this. So if a judge were or a jury were to find someone guilty of this secondary offense, they could sentence them to 1 day on and after. They could stay a sentence. They could suspend a sentence. There's no minimum mandatory. It just says consecutive. So whatever they get has to be after this. But it doesn't say they have to sentence them to a certain amount of time or a certain punishment. So they still have a lot of discretion. Representative Newell.
Thank you, Mr. Chair. I will be voting in support of this bill. And I just wanted to, I've been an activist and an advocate for quite a while. And one thing that we say is that stories are the most important thing. You share your story, it connects with people on a human level. So the most important thing for me about this bill is for people to be able to connect beyond what the criminal justice system and punishment can do, but be able to connect with the perpetrator and hopefully get to a point of healing and hopefully make a really true impression with the person who's committed these crimes. And that's my hope. Thank you.
Thank you. And in response to that, I would say, how many times have we seen, to the shock of us all, where the victim has said to the defendant's face, "I forgive you." And that is part of their healing process, to be able to even say that. And that could be taken away by someone not showing up as well. Representative Selig again.
Thank you, Mr. Chair. And pardon the interruption. We have a delegation who's come in from Macedonia to observe us for a little while. And I just wanted to welcome them to our executive session to watch our proceedings and how we are able in a bipartisan way to discuss issues.
Thank you, and welcome to the New Hampshire House and to the Criminal Justice Committee. I'm not sure if you speak Greek or what language Macedonian is, but I only know English and German, so you're going to get English today. Representative Muse.
I do wish that we would have had the opportunity to hear other folks with more knowledge of our legal system weigh in, as we usually do on bills like this. And I understand that we're under a very, very tight time frame. I intend to support the bill. I also intend to go out and ask some of those folks what they think about this bill, if they think there are things that we may want to adjust. And if we do find things like that, we will address them in a floor amendment. Thank you.
Thank you. Representative Newman.
Thank you, Mr. Chair. I disagree with that there is not a mandatory minimum here. And the reason I say that is that if you look at line 23, it says the person is guilty of a Class A felony if having been charged or awaiting a sentence for an offense punishable by life imprisonment or imprisonment of a maximum term 15 years or more. The person knowingly fails to appear or refuses to comply with a transport order, that they are guilty of, let's see where I can find that. They're guilty of a Class A felony. And then if you go to what I brought up earlier, which is line 3 on the next page, that says the term of imprisonment imposed by pursuant to this section, and the term of imprisonment is whatever I just described, it shall be consecutive. It doesn't say it can be reduced. It doesn't say anything like that. So you could end up with 2 consecutive 15-year sentences, and the second one, in my opinion, is a de facto mandatory sentence. So that is a big problem for me with this bill. I think that language should be changed, but I am going to support the bill and just put that out there so that it can be dealt with wherever.
And I appreciate you being willing to do that. And I would encourage you to talk to someone from the court or an attorney because I'm fairly confident that it's not a minimum mandatory. The consecutive is mandatory, but what you get sentenced is not mandatory. Because you are found guilty of a Class A felony, the judge still has discretion as to what he sentences you to for that Class A felony. There is a sentence up to you can be sentenced to, but whatever he sentences you to, he could suspend it. He could do all kinds of things. But if you are sentenced to incarceration, it would be on and after. That portion is mandatory, but the amount is not. But we can work that out, and I appreciate your support of the bill this morning. Further discussion? Seeing none, I'm going to ask the clerk to call the roll. At this point, the motion on the floor is ought to pass.
Vice Chair Rhodes,
Yes.
Representative Pratt,
Yes.
Representative Sitek, Representative Prue, Representative Janvin, Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Brennan,
Yes.
Representative Murphy, Representative Newman.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Selig,
Yes.
Representative Wheeler,
Yay.
Chairman Roy,
Chair votes yes.
15-0.
By a vote of 15-0, the motion about to pass carries. I understand there's going to be some discussion regarding possible floor amendments. At this time, I would like to put it on the consent calendar. If we need to pull it off to do something with it, then we can do that. Is there an objection to consent at this point?
I object.
Okay, so it's not going to go on consent. With that, I close the executive session. Okay. I'll start with public. I'll do the report. Now I'm opening the public hearing on Senate Bill 482 and invite the prime sponsor to introduce the bill.
Good morning, Mr. Chairman, and good morning, honorable members of the House Criminal Justice Committee. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 482. It seeks to give the New Hampshire Air National Guard, Army National Guard, and the 157th Air Refueling Wing offices of the Staff Judge Advocate access to criminal records, criminal investigation records, and court records of New Hampshire National Guard employees and service members for the limited purpose of carrying out the office's responsibility. This proposed legislation provides statutory authority to the New Hampshire National Guard attorneys to access the confidential criminal records, history records, criminal investigation, documentation, and public court records of current National Guard personnel. This proposed legislation would provide these attorneys with the same access that local, county, and state prosecutors have. There is currently no New Hampshire statute that provides the New Hampshire National Guard military attorneys with the authority to obtain confidential criminal history records or criminal investigation documentation. As such, they have obtained drastically different responses to record requests to state and local law enforcement agencies. The range of response has varied widely from a full release of an investigative case file to denial, because the law enforcement agency treats the request as a right-to-know request. Under the latter, no New Hampshire National Guard attorney has been previously advised that no information would be released unless authorization is obtained by both the alleged offender and the victim. The proposed legislation would enable the New Hampshire National Guard to take appropriate security measures and, when appropriate, take necessary administrative actions against soldiers and employees based upon the information collected through criminal investigations. This is something that is, quite frankly, very, very important. Many of the National Guard members, as well as the civilian employees, have security clearances, and they handle highly classified documents. And if a National Guard member or employee has come into contact with any kind of civilian legal authorities, that could affect their security clearance and whether or not it would get revoked or amended. But right now, they don't have the ability because they can't uniformly get those records. Because the potential actions that may be taken are not judicial in nature, the due process rights within the New Hampshire criminal justice system of the National Guard employees and service members would not be affected by this legislation. I'm not sure if any of you know, but I teach at the Community College in Nashua. And when I teach a section on our judicial system, I often say we have three judicial systems. We have the federal, we have the state, and then we have one that we voluntarily submit ourselves to, and that is the military. It's very, very different than a civilian system of justice, and many people don't realize that. The proposed legislation does not provide access to the police records of a New Hampshire citizen who is not a New Hampshire National Guard employee or service member. At this point, Mr. Chairman, I will conclude my testimony. The Commanding General of the National Guard is here, and he can answer any of your questions. So I would again thank you all for your time this morning. I appreciate that. Thank you very much.
Thank you, Senator. We will reserve the questions for the thing.
Thank
you
you.
for your time in bringing this bill for consideration. The chair calls General Michaelides.
Good morning, Mr. Chair, committee members. For the record, I'm Major General David Michaelitis, the Adjutant General of the New Hampshire National Guard. And with me here today is Captain Ryan Ollis, a military attorney, a former county prosecutor. So it's this simple. We are a standards-based organization. This is about good order and discipline. If inappropriate actions occur in the outside, in the private sector, we don't have positive authority to coordinate with civilian law enforcement agencies to find out what our service members may have done. Based upon the Privacy Act and so no law enforcement agency is the same within the state. They have different jurisdictions. So the challenge we have is if inappropriate, we may or may not find about it, or we don't have access to those records. So the senator alluded to the fact that security clearances, that's one. Same thing as domestic violence. If a service member commits a domestic violence, is convicted of it, that affects their employment. They can't carry a firearm, they are non-deployable, and we kick them out of the service. So having access to criminal records allows us to instill as a standards-based organization good order and discipline. No more, no less. And subject to your questions, like I said, I have a military attorney here who can answer any questions you may have. Thank you.
Thank you, General. My first question would be, does the CID currently not have access to, if they open a criminal investigation on the military side, to the civilian records?
This is Captain Ollis. CID will conduct investigations for active duty soldiers who are under Title 10, but most National Guard soldiers are under Title 32 status. And when they're on state active duty, they're under Title 5 status. So CID will not investigate, and therefore we don't have access to CID's access to military records.
Okay, I see. So the National Guard doesn't have the same, an agency equivalent to the CID to be able to carry out those criminal investigations without being able to get these records.
Correct. Yes, sir.
Thank you, Captain. Further questions? Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. I think, it sounds like a good bill. My question is, do you think that this is limited enough in scope to people within the National Guard, et cetera, who would need to have this information for the purpose of carrying out this? Or does it leave it open to being open to anyone in the National Guard?
So the bill only provides access to military attorneys, judge advocates. It is limited to attorneys who would be advising commands as to how to enforce good order and discipline. It doesn't provide access to commanders, NCOs, or anyone else to request and get criminal histories or criminal reports.
And ma'am, to give it context, we have about 3,000 uniformed service members. We probably have about 15, 18 military attorneys.
Okay, thank you.
Captain, could you please, just for the benefit of the committee, if you could, and I know this is a big ask, in like a minute, explain how the Judge Advocate General Corps is both the prosecutor and the defense, because it can get confusing. In other words, in your prosecutorial role, you might pull these records, and the guy who prosecuted yesterday might be assigned to defend that same soldier the next day. Could you explain that for us a little bit?
That used to be the case, sir. However, that's no longer the case. Judge advocates are either assigned to a commander, and such as myself, I'm a brigade judge advocate, and I have another captain who is a military justice advisor. We advise a 06 colonel on military justice in all operations. However, within our state, in the New Hampshire Army National Guard, we have a 02 First Lieutenant, Lieutenant Urdia, who is a trial defense services judge advocate. His sole role is to defend soldiers within the state of New Hampshire, and his chain of command falls outside of the state of New Hampshire. So his rating chain goes to a person in Massachusetts, to another person in Pennsylvania, up to someone at NGB. I previously held that role for a number of years, and it ensures that soldiers are not under the influence of command within the state and can do the best job to zealously advocate for that soldier. The Air Force has the same type of thing. I believe it's called Area Defense Council.
Well, I'm glad to see things have changed for the better in 30 years. Any further questions regarding this? Representative Muse.
Thanks for taking my question. My assumption is there would need to be some violation of military justice in order to precipitate this type of records request, or does it work the other way? Would you actually want, I guess, do you envision this also working perhaps as a notification system that would essentially allow you to be notified if a soldier was found guilty of something like a domestic violence charge? I'm a little curious just exactly how you envision the statute working.
Sir, I don't think the statute is written to be a notification system. I don't think that it creates any burden on law enforcement to actually inform the New Hampshire National Guard that there has been a conviction or any interaction with law enforcement. However, it does enable us to get police reports. The intent is for us to, upon finding out that a soldier has been involved with law enforcement, to reach out to law enforcement and get the police reports and to take action in that regard. Generally, when soldiers have been involved with law enforcement, it creates either a security issue that we need to review, or it creates, as you said, a potential violation of the Uniform Code of Military Justice.
Follow up? So the way that I read the statute, and please excuse me, I've read it about 2 or 3 times, but the way that I've read it is that it not only would allow you to request records for an individual soldier, but it almost looks like the way it's written, you could actually request the records of all your soldiers. Is that part of the intention behind this?
No, it's not, sir. It's the first one, right? It's a function of if there's a domestic violence issue, right? Generally speaking, on minor misdemeanors, soldiers self-report. They'll tell their chain of command, like I got a speeding ticket or I have DUI, but sometimes when there's inappropriate behavior, we may not be notified. So then for us, you're trying to search for the information to ensure that, hey, listen, did that really happen? And that's when sometimes our Privacy Act, like the civilian law enforcement may not share it with you. So it's the same thing with domestic violence, sexual assault. We just trying to get aware of that specific issue for that specific soldier. And like Captain Allis alluded to, is they're assigned a military attorney, judge, advocate in their defense when we take the disciplinary action.
Thank you.
With regard to security clearances, not knowing about a soldier's potential civilian problems, could that make them open to possible blackmail? Because someone could threaten to out them to their command if they didn't reveal certain information or things like that. Could you touch on why it's important that there's full transparency for someone who holds the clearance?
That's probably you, sir.
No. So I would say this, we have several positions or job categories that require different security clearances, right? There's a standard secret clearance, there's top secret, and there's other sort of caveats associated with that, right? So for example, all our military, police, and security forces, both in New Hampshire Army and Air National Guard, require security clearance. So you are correct that if inappropriate behavior occurs, and we do not know about it, to revoke that security clearance is actually somewhat of a big deal. And there was an unfortunate issue in Massachusetts recently that sort of brought to light some of the issues with security clearance and who has access to what type of material. So yes, it is a big deal.
Thank you. I guess what I was trying to point out is if someone held a highly classified security clearance and had certain information and the command wasn't aware of what they were involved in the civilian law enforcement, someone seeking to get information from them could say, unless you want your command to find out about this, you better do what we say. It makes them susceptible to losing their clearance because of that. Any further questions? I think everyone understands how important this is. Seeing none, thank you. Oh, did somebody else? Did you have one? Oh, okay. Thank you, General and Captain, for coming today. And I think we have a pretty good grasp of this. Thank you very much.
Thank you, sir.
Thank you.
Chair calls Kevin Grady.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. For the record, my name is Kevin Grady. I'm a 25-year Air Force veteran, and I'm a 25-year resident of the town of Hooksett, New Hampshire. Today I'm here representing the 20-member organizations of the State Veterans Advisory Committee, and we are chartered by state law 115:A-8 to speak for the veteran community in New Hampshire. And one of the things we do is we look at bills that have veteran impact, we take a position on them, then I come and tell you what that position is. We do wholeheartedly support this bill. We think that where possible, civilian law enforcement and military law enforcement should work hand in hand to the best that they can. And I want to share a story that from my career on active duty that might put some of this a little bit into perspective for you. In the mid-90s, I was a flying squadron commander down in Panama City, Florida. And one day I get this phone call from this man who says, I'm with the National Security Agency, and I think that you should revoke Sergeant so-and-so's security clearance for that possession of marijuana conviction he had 3 months ago up in Alabama. And I went, excuse me, what? So I had no clue whatsoever that any of this had happened. As far as security clearance items go, this man had a security clearance because most people in the Air Force do have a security clearance, but he held a job that he was packing my parachute. He was in my life support shop. I'm not sure I want that person, you know. And then when I got into the background on the arrest thing, there was a traffic pullover. They were literally smoking it in the car while they were driving, and so that's bad. So having this knowledge is where we can work together is a good thing. And I have also seen it in my career where, you know, the relationship is so good that the military and the civilian folks get together and say, do you want to do this, or do you want us to do it? And then they sort of pass it off and say, yeah, we'll go ahead and let you do it. And just because somebody is tried in the civilian world for a crime doesn't mean that non-judicially I can't do things like give them letters of reprimand or take stripes away from them or take pay away from them, those kinds of things on a non-judicial basis. That's really all I wanted to tell you. We do support this bill, and we hope that you'll move it along.
Thank you. Any questions? Just to touch on that, I think that if anyone ever watches like NCIS, do not believe that. That's not how that works. Military police are not out there investigating crimes in the civilian world.
No, they're not.
No further questions. Thank you for your testimony.
Thank you, sir.
The chair calls Victor Muzzy from the New Hampshire State Police. Captain Victor Muzzy. I always forget your rank.
Thank you, Mr. Chairman and members of the committee. I just wanted to speak very briefly after speaking to the good captain here behind me about the intent of the bill. Originally, our fiscal note, I think, kind of addressed the costs associated with our state criminal conviction record and also the FBI record. And as I understand it, it's really not about necessarily the criminal record. It's more about police reports, if you will, and court records or documents and things like that. And from the law enforcement aspect, I can understand some of the apprehension that maybe some departments have had relative to releasing these records. Like if it's not an arrest report or an arrest record, but rather an investigation report, there might be some apprehension there given the defendant's position. You know, are we going to get sued if we release this report? Who are we releasing it to? You know, for what purpose? What does it get used for? So I think this bill will clarify that and allow some protections, I think, to the agencies where these gentlemen may be looking for reports, legitimately so. And this is really a matter of public safety and public service. And it certainly makes sense to me that these things be available consistently for these folks to do their jobs for the reasons stated. And so I just kind of wanted to correct, I guess, the fiscal note from our perspective. As the good captain tells me, it's not about paying the $25 to the Department of Safety. It's more or less just having consistent access to these things. And so for those reasons, you know, I think we would support the bill or the idea behind it. It makes sense that there's equal access to these things for this limited purpose. And I appreciate the questions about whether this would open up other people to getting a hold of it. And I like the idea that, no, it's specifically for these judge advocates in that process. And I think that's all I have. So I'm happy to take any questions.
To the best of your knowledge, there's nothing in this bill that exempts them from the unlawful distribution of criminal offender record information, is there? They would still be held to the same standards as a New Hampshire law enforcement officer would.
Correct. That's my understanding of it. Yeah. It just allows them what I would consider consistent access. In the brief conversation we had, it sounds like one agency may be full willing to give them everything. Another agency makes them jump through a bunch of hoops to get what I would call or consider basic sort of records to have an understanding of what occurred. So I think the same standard would apply relative to the federal record and the state record and the privacy, inherent privacy protections that are there for those.
One more question. I'm not sure if it should go to you, to the other captain. Do you currently have the ability to access federal III records, or do you not have that ability without going through a New Hampshire law enforcement?
We tried to briefly discuss that, and I'm not sure
So we don't know.
what the answer is, but
To be frank, sir, I don't know if we had any difficulty going and getting those records through New Hampshire law enforcement. We would contact federal law enforcement, and we've never had any problem getting any records through federal law enforcement.
I just wanted to make sure that this encompassed enough because of the fact that we are surrounded by several states where your soldiers could go and get in trouble. If you couldn't get that record from a New Hampshire law enforcement and Maine said no, or Vermont said no, you'll be back to square one again. So I want to make sure that our people are covered. So, okay, if you can get it from the FBI, that's fine.
yeah, that's what I was going to say, Chairman. I just think, from our perspective, if they have another avenue to get it that doesn't involve safety,
Yep.
If the expectation were that we were going to disseminate it, that would be probably another conversation and maybe some cleanup language, if you will, in either this, RSA or another one, just to ensure that we were authorized to do that for that purpose. I mean, in my mind, these gentlemen are law enforcement as much as I am, or public servants as much as I am, and so I just would want to clarify if there were an alternate path that was an okay practice, But it sounds like they have alternate means to be able to obtain that, so that's good.
Good. Excellent. All right. Seeing no further questions, thank you for
Thank
your
you.
testimony, Captain. Is there anyone else wishing to testify in this bill who has not already done so? Seeing none, I hereby close the public hearing. What's next? I'm opening the public hearing on Senate Bill 376 and invite the senator to introduce the bill.
Good morning, Mr. Chairman, members of the committee. I'm Senator David Waters, District 4, here to introduce Senate Bill 376, establishing a corrections education and vocational planning group. I will just briefly say about the bill before we return to it a moment that you'll see it establish a corrections education and vocational planning group, certain folks on it, and then a set of duties, which I will discuss in a little more detail later. But I'd like to provide first a little context about why this bill came forward and why this is going to be a very useful tool for Department of Corrections to move forward on education programs. I have a handout that is going around. This bill arises out of the fact that the federal legislation has reestablished the Pell program for incarcerated people. It's a second chance Pell program. Pell education grants for incarcerated folks was eliminated back in the 90s in the crime bill, and there's been a desire really arising from the prisons themselves and others to say this is one of the best tools we have to help recidivism, workforce development, and atmosphere within the prison is to be able to have these educational programs available, and the funding for them then can come through the Second Chance Pell program. So a year or so ago, the New England Board of Higher Education, on which New Hampshire is a member of, is the 6 New England states which deal with all kinds of educational policy, they got a planning grant, set up a commission to look at how we're going to respond. What should the states do? What should our departments of correction do? What should our university and community college system do to be ready for second chance Pell funding? And so you have before you a few pages of that report, a little description of what NEBI itself does, and I will mention that we have representation on the executive committee of New England Board of Higher Education from our university system chancellor, the chancellor of our community college system, legislative representative, that's myself, and then a legislative advisory committee of New England Board of Higher Education, which has several legislators from both bodies are members of that. There was a larger funding received for that effort from Ascendium Group, and I just now has been announced that Ascendium has provided $6.7 million to the New England Board of Higher Education to provide grant funding to the states. So we'll have a good opportunity to get some funding to help set up programs that we're gonna set up. You'll see on the third page of the handout, which I'm sure you all on this committee are familiar with the benefits of this. Education and prison programs help with facility safety. They help with public safety in terms of people returning. Self-efficacy, people are, take charge of their own lives through educational programs, and then are ready to go out into the workforce and reintegrate into the communities as they continue their education. What the commission recommended was to look at prison-based issues. What do we do to ramp up these programs? What are facilities, technical, and other kinds of needs that might be on that? And then what kind of partnerships the community college system? We already have, once the Pell Grant eligibility became clear, there were an early desire from the community college system and Department of Corrections to set up a partnership with White Mountain Community College to start ramping up educational services, and we'll hear more about this. But also then community-based. What do we need to do to have support services and make it seamless? So credits can transfer, and that people, when they emerge from their educational programs in prison, if they want to continue their education, if they haven't completed a degree program, we'll be able to have the community wrap around the easy entry into our community colleges and university system. There are a lot of recommendations that came out of the commission. That's what commissions do, as you know. I wanted to focus in this bill on the state level recommendations, which you will see listed on the next page of your handout. And so what this bill does is it provides us really with the liaison through this body that the bill will set up so that we can work with these partners in state and out of state to do what we need to do for our Department of Corrections. Other states around the region are taking similar approaches to this or somewhat different approaches that, each state is different and the Department of Corrections is different as well. So just to return to the bill, you'll see who is on it. I do really want to commend the leadership of Commissioner Hanks, and we have Nick Duffy here from Department of Corrections, who have been really instrumental not only in the commission when it was meeting last year, but also in shaping this bill so that it could work for the Department of Corrections. And then also want to particularly thank both the university system and particularly the community college system, because they're the first ones who will be stepping up to help provide these programs. You'll see other people who will be connected to the goals of the overall program: rehabilitative services, Department of Corrections, employment security. So we can have a sense of how is this education, the kinds of programs people are going to take and actually connect to jobs that they can get. And I will note that a lot of businesses now are actually looking at apprenticeship programs and work opportunities for incarcerated folks. And so it'd be a good opportunity to, I thought, to make sure we're having the education connect to actual skills and employability. And that's why we also have the Department of Business and Economic Affairs, of course, Division of Adult Education. We will certainly be looking at those incarcerated folks who may need some adult education services to make sure they're ready to take college level courses. And then a designee from the New England Board of Higher Education, because of all the money that potentially will be flowing to us from the Board of Higher Education to help fund through grants some of our activities. I thought that would be a good person to have on here, and get some advice, somebody who was formerly incarcerated and did education in prison as well, so we can know kind of what works for the people that we're hoping to focus on in this. So you'll see the duties here, and as you're familiar with in these kinds of bodies, the kinds of things they need to do, starting at the bottom of page 1 of the bill. What kind of partnerships do we need so we make sure that credits work and programs work, credit impacts. That's something that's important now throughout the system. We're trying to create this seamless flow from high school to community colleges to university, and we want to make sure that whatever programming and educational program people take in while incarcerated, that they have a seamless credit transfer when they want to continue their education. Any college readiness programs that we might need through adult education. Are there ways in which we don't have to reinvent the wheel? If there's a good program or course being offered at another New England college or university through the New England Board of Higher Education, one of our huge benefits out of that is that we get New Hampshire students of any kind get to take courses at the other institutions throughout New England if they're offered without having to pay. So that might be a way to save us some money and the costs of setting up programs if there's already one existing that people can participate. Look at the labor market needs. As you know, we're looking to build a new men's prison. We have a pretty good facility for the women now, and so in that process, ongoing discussions about are there going to be facility needs now and in the future for educational programming and career pathways, how the Pell Grant funding might be supplemented when individuals leave incarceration. And I've had some conversation with the university system, and they have their Granite Promise where they agree to top off the costs beyond what Pell Grants provide, and that would apply to this population as well. Take a look at, are there going to be any budget needs and where can we get some funding? I've mentioned we'll get money through the Ascendium grants. You've got in your handout a couple of, this has just been announced, but a couple of preliminary things of how the money's going to flow over the next few years and the kinds of buckets that it's going to go into. And you can see the opportunities that we will have there for this. And we'll get some reports. So that's the bill, Mr. Chairman, and a little bit of the context. And we have some folks here from community college system and from Department of Corrections, and you can focus in on some of those things with them, but I'm be glad to answer any questions you have now.
Thank you. Could you tell me how this came out of the Senate? What was the vote? Did it come out unanimously? Was this
Yeah,
close?
yeah,
Oh, very good.
yeah.
Excellent. Further questions for the senator? Representative Wheeler.
Thank you, Mr. Chairman. And thank you for taking my question, Senator Waters. My first question has to do with, I'm on page 2, line 18, where it's talking about the CEVPG, what they shall do. And it says, especially in coordination with the England Board of Higher Education. Do you mean New England Board? Yeah.
Thank you for correction, a typo. All the Senate eyes that looked on that.
I figured, we want to be
Senate
New
tried to
Hampshire
slip
here.
one in to go international on us.
Can I ask a follow-up,
Thank
Mr.
you.
Chairman?
And I'm an English professor, you
Yeah,
know.
there you go.
Thank you, Representative Wheeler.
Absolutely.
At what point will Oxford be involved in this? Go ahead, Representative.
Thank you, Mr. Chairman. My follow-up has to do with page 1, line 17, where you state that a formerly incarcerated person appointed by the Director of Rehabilitative Services will be a part of this. And I just was wondering what you think the criteria that the director will use to choose that person will be.
Well, thank you for the question, and I'll answer it in two ways. I mean, Nick is here, and he can tell you. But I think this is important in part because of the experience that we had on New England Board of Higher Education Commission, where there were quite a number of formerly incarcerated folks, and such a range of people who'd gotten out, started very successful businesses, or doing other interesting things with their lives, and they could talk very directly to the impacts, but also what programs worked, in the incarcerated setting. What do they need? What worked? And the message we got loud and clear is we want things that really can contribute to our being able to get out into the world and have a good job. And so that was very important to hear. And the gamut of people, what they studied, it was from some social work to finance, psychology, the commissioner of Department of Corrections, Hanks, wanted us to change the title of this to include vocational, which is good. So anyways, I think that's what can be contributed here. And the criteria, what I had imagined and discussed on this was that it'd be someone who had participated in educational programs while incarcerated. And then otherwise, I think Nick Duffy can tell you, because he's the person who, handles post-release and post-release.
Representative Reed.
Thank you for taking my question. Currently, residents could take classes while incarcerated and pay per credit. And I just wonder what's going to happen when the grant money does dry up. Is this going to be a burden for the taxpayers?
Thanks for the question. Unless the Congress repeals the eligibility for Pell Grants, this funding will be available for the foreseeable future. So it's like Pell Grants in general. It's the Pell Grant program has been around for a long time and funded for a long time. So that's what's driving this. Now the grants and things, I think, are kind of startup funding. That's why on page 2, consider, I think the question you raised is a good one. What about the taxpayer? And that's why I put on line 16 on page 2 we really ought to hear from this group just that answer to your question, and how do we plan for it. But I think the federal money is pretty secure for as long as there's Pell Grants in the future. And if there are any additional costs, we gotta get a handle on it.
And to be clear, this legislation doesn't commit us to spending any money. It just commits them to telling us if they need money and why. Is that correct?
Thank you, Mr. Chairman. This, you know, like most of these, this is coordination and study. That's what the bill is.
Seeing no further questions, thank you, Senator.
Thank you very much.
And the chair calls Joe Haas.
Good morning, Mr. Chairman, members of the committee. My name is Joe Haas. I live in Gilmanton. I put my post office box on my pink card, and I put 3 minutes, and I have 3 items I'd like to talk about. And number one is page 1, line number 22, where it says other, and then it has the word corrections, but before that it has higher education. So after the word education should be like county houses of correction. The superintendents should be included, I think, in order to have that other for corrections, because there's no corrections before that in that paragraph, Roman numeral 3. And on line number 19 above that, where you have OPLC, that's Office of Professional Licensure. That's currently headed by Lindsay Courtney, the attorney, Michael Courtney's wife. He's at Upton and Hatfield. She's working over there. And I'd like to add in there maybe the OPLC director in good standing. And when I say good standing, because I was over there yesterday, and I have a real estate complaint there of June 2022. They take up to a year to investigate. It took 14 months for a decision, and it took another 6 months for the decision to be sent to me. That's ridiculous. And even the chairman over there, Mr. Valentine, he says, we got to get this backlog dealt with. And it's just like the Human Rights Commission. I don't know if you heard about that or not, but she asked for 4 more investigators. Governor Sununu said, I'm going to give you 3. She said, no, I need 4. So she got 4. And there shouldn't be a backlog to begin with. I just am upset that, you just presume that the executive director is in good standing over there. That's my, beef with the process over there. It's not, it's free. There's no charge for a filing fee for a complaint, but it's not complete, and it's not, Article 14, free, complete, and prompt. My Bill of Rights. It's not. And my last point, number 3, is on page 2, line 16, where it says federal funding, and I'd like to add in, just like the, let me give you an example first. The U.S. Marshal over there at the federal building, it says his oath of office is to execute lawful precepts. And I saw the U.S. Marshal woman over there yesterday. I said, well, what does that mean? Does that mean that some are unlawful? And, I won't get into all the detail, but I just would like to put in there, before the word federal, legal and lawful federal funding. Because this state operates, I was told by Bob Guida, him, former senator, he told Dan Richard, who told me, he said this state operates on 40% federal funding. So unless that federal funding comes in, a lot of these state things aren't going to be done. And I'm really upset with the feds. I mean, if somebody owes money, like on a tax, do they have a course with X number of classes in that subject matter of incarceration? My friend Ed Brown over in Plainfield, he was arrested, sent to the FCI, Federal Correctional Institute. The word correction is, you have courses with classes. There are none in his subject matter. And it was Judge Nathan Clifford of the U.S. Supreme Court. He was born in Rumney, New Hampshire in 1875. He put it on the books, the Morsel case. He said you squeeze the creditor down to half their freehold and make them pay from that estate, their homestead. They use the tools of their trade. You don't just send somebody to prison and send you and me the bill for their upkeep. I'm very upset with, there's a lot of education stuff in here, but not too much on correction. Thank you.
Thank you for sharing your thoughts with us today. The chair recognizes Shannon Reed.
Good morning, Mr. Chairman and members of the committee. My name is Shannon Reed. I'm here representing the community college system of New Hampshire. A couple years ago, a couple of our institutions were approved for sites, campuses to offer second chance Pell prison education programs. We currently are working with students in the Northern New Hampshire Correctional Facility. Our campus up in Berlin, New Hampshire, White Mountains Community College is the campus that is offering those programs. The initial group of students started about a year ago in March, taking classes in business administration and liberal arts programs, working toward their associate degree. We have been working closely also with our colleagues at the University System of New Hampshire to work on transfer pathways for those students when they complete their associate degree, for those who wish to continue their education at the baccalaureate level. And we are also grateful for the partnership with the Department of Corrections on this program and area. Offering prison education programming is not without challenges. So the idea of a planning group that can bring together relevant stakeholders is a very good and useful, beneficial idea. Matters like coordinating planning and evaluation and looking at what can be available for resources are matters that this group could work on together effectively. Senator Waters mentioned one of the sort of attributes or expected outcomes of prison education, and one of them is self-efficacy. And I'd like to just share a brief story with the cohort of students that we are working with up at White Mountains Community College at the Northern New Hampshire Correctional Facility. They told a story where they tried to advocate for something a few months before the program started. I think it was additional recreational time, and it didn't go very well, their attempts to advocate. But they said after we took our first college composition course and we learned things like how to communicate differently, how to communicate more effectively. And then they went back and they tried again, and they were successful that time in getting what they needed. And so not only does this type of program help incarcerated individuals post-release in getting employment and avoiding recidivism, but it also helps them to kind of learn and practice those skills while they're still inside the walls and maybe improve their lives there and create a safer environment. So we're very supportive of this bill. We thank the sponsor for engaging us in its drafting, and we look forward to working as part of this task force if this bill does get passed and enacted, and I'm happy to take any questions.
Representative Muse.
One thing I'm just guessing is that you can't offer all of your curriculum to folks. So how do you make that decision, or is that something you're looking for guidance on?
I would say that there are a lot of issues that have to do with things like, first of all, faculty who are available and willing to teach, within a prison setting. Things like equipment and technology that can or can't be used in a prison setting. So those are some of the considerations. I might defer to Mr. Duffy from the department to be a little more specific about that. I myself am not directly involved in the program, so I might not have all the details that folks would be looking for.
Further questions? Seeing none, thank you for your testimony. Chair calls Mr. Nicholas Duffy.
Sit on now. Thank you for allowing me to speak today. My name is Nick Duffy. I'm the Director of Rehabilitative Services for the New Hampshire Department of Corrections. Again, as Senator Waters was mentioning, education is extremely important for individuals incarcerated, from making sure that they have the skills needed upon release. It helps lower recidivism. There's study after study that shows just how important that education is, and then the higher level of education that somebody can get while incarcerated means that level of recidivism continues to decrease. So with each degree, level of recidivism drops drastically, and that is through the RAND study that information is. So you can look that up. We believe that this committee would be extremely beneficial. And although we are doing these connections now and having some of these conversations, but bringing this together with specific goals in mind in order to not just the Department of Corrections having those conversations individually with each of these groups, but all the groups coming together. There's a lot of resources, ideas. Each state is doing things a little bit differently. And so collectively coming together and having these conversations and figuring out how to, for long-term sustainability, to make sure that it just isn't put on the taxpayer to pay for programming or the residents to try to find a way to pay for this themselves, but a way that we can find long-term sustainability, keep costs down, and provide as much education as we can during their incarceration. Thank you. I'm willing to take any questions you have at this time.
Representative Selig.
Thank you, and thank you for taking my question. I'm wondering if you might be able to share with us an unexpected success story from one of your, someone who participated in this kind of a program.
Yeah, so I think that there's a lot of success stories that I could probably draw from, but overall, I think that there was a couple years ago, one of our high school graduations, there was a individual who was struggling to sort of keep up with his high school education, and his son was going to drop out of school. And he said that he basically came up with an agreement with his son: you stay in, I'll stay in, and sort of they completed together. And I think that's the kind of thing is it's not just even about them, but it's about generational incarceration and generational impacts that this has. And so the more that they can get and see that, okay, my dad was able to do this or mom was able to do this, the more that their children can see, okay, now I can do this as well. So although that was a high school example, I think that the example that they're setting to their children, the example they're setting for their own future. And he said it was a rough patch, but he was able to overcome it and has been extremely successful since. So.
As part of the work product for this group, will it be kind of a sort of public relations type thing, whereas you're going to show the return on investment to be able to, so that whatever portion does end up coming from public funding, that the cost benefit it weighs in favor of helping with the education versus further incarceration, given the current public issues regarding student loan debt. I feel like there will be some people saying, well, wait a minute, why are we doing this? And the mine's not getting paid, to show them, well, actually it saves you money by doing this, that type of thing.
Yeah, absolutely. And I think that's where grants are really helpful, because they can show the success of something and then say, well, yes, it might cost a little bit more long term for us, but this investment can save us so much more down the road. And I think that's really what we need to show. This is not just about doing it, but is it working? And we don't want to have programs that aren't working and just sort of waste of money. We know that these types of investments have shown to be successful, but we need to show it's successful within our own programs as well, and bring that data forward and say in our reports and what we're reporting, this is what the impact has been.
Very good. Thank you. Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. Last year, in a hearing about sentencing, we were talking about essentially what would commonly be known as, time off for good behavior. And one of the, was a variety of programs that you could go through. We had someone who came in and spoke to things like education being one of those, where the financial, they did not have the financial means to be able to do that. So I was wondering if you could speak a little bit to the way that this levels the playing field for people to be able to, rather than having a financial barrier, having it be based on merit and their determination and what they do with it.
So currently with earned time credit is that there is already that in place where they, depending on the degree they get, they can get earned time credit for. Currently, right now, they would have to pay for that themselves unless they're participating in our current Pell classes. So you're right, is that somebody needs the financial ability to be able to do the correspondence courses or participate in that way. This really would be about, our current standards are more about remaining as doing the right things, remaining disciplinary free, making sure that you're being a good citizen within our environment to be selected for this this program. And so there's a huge advantage for us as well, just from a behavioral standpoint, to get people to do the right things in order to go into this program. So in that respect, somebody who has a financial barrier to pay for higher ed, well, that will remove that financial barrier. Again, this committee itself is really, we're already working toward Pell Grants, and we're already doing Pell Grants, and so that's already happening. I think this committee is really about ensuring long-term sustainability of those programs. Yeah, thank you.
Representative Rhodes.
Thank you, Mr. Chairman. Just trying to look at it real quickly. So if it's in here and I pass it up, please excuse that. Would this be effective for every person regardless of whether it's a life sentence or not?
Pell, you mean Pell funding? Can you get Pell funding regardless of your sentence?
So the education that is being discussed here, would that be available to every inmate regardless of the sentence?
Yeah, so we offer education to anyone regardless of their sentence structure. So whether they have a life sentence or they're going to be there for a various amount of years. However, priority is given to people who have less time to achieve that while incarcerated. So if somebody only has a couple years, they would probably be able to get into the program quicker if there's wait lists for that program, because we want to make sure that they can get that prior to release. If there's room in a program, space available in the program, we do allow any sentence structure to participate. And I think there is data to show that even for individuals who aren't going to be released, there's benefits to that, just institutional behavior and other factors.
Seeing no further questions, thank you for your testimony.
Thank you.
Is there anyone else wishing to testify in this bill who has not signed up to do so? There being none, I hereby close the public hearing. I hereby open the public hearing on Senate Bill 322 and recognize the senator to introduce the bill.
Well, good morning, members of the House Criminal Justice Committee. It's great to be here. For the record, my name is Senator Howard Pearl. I am the senator from District 17. I live in the great town of Loudoun. I am here today to introduce Senate Bill 322. This bill requires a licensing authority and, this bill requires a license authorizing an individual to carry a loaded pistol or revolver in the state to include the name, title, and signature of the person issuing the license. The bill further provides immunity to law enforcement officers who in good faith issue these licenses under the RSA. So the background on this, why I put this bill in, which is always important, is a constituent came to me with a situation where they had received a license to carry. And, as you recall, back when we did constitutional carry, we left that provision in that folks could get a license so that if they wanted to carry in other states, they could enjoy reciprocity. And the individual that came to me, their police chief would not sign the license because for reasons that they had an issue with the constitutional carry itself, not so much the person, not my constituent, but they just didn't want to sign any of them because they felt that the constitutional carry provision had taken away their ability to decide if someone was suitable or not and only allowed the federal prohibitions on whether they could issue a license. So when that happened, this now leaves you, me, anyone else whose chief decides that they didn't want to sign the license with a a carry license, but it's not signed. Well, that's a potential problem if you're traveling and you want to go to another jurisdiction where they recognize our license, and we have reciprocity with them. You get in a situation where you get pulled over for whatever reason, you're now carrying a firearm with a license that's not signed. That's a real potential issue. And so that was the genesis for me putting in this bill. And as you'll see, all it does is it requires that the issuing municipality, that the officer who's issuing it, that they sign it and that they put their name, title, and their signature on it. Now, in return, we made sure, I believe they already had immunity from acting in their capacity as an officer and doing their official duty, but just to be sure, we also included the immunity clause in this bill to make sure that it was very clear that they had no personal liability on doing their job. So that is the nuts and bolts of the bill. I do have my constituent here today to testify on the bill as well, so that she was willing to come in and step up and tell her story here as well. So if you'll have an opportunity to hear from her too, if you have specific questions for her about the court situation that she went to try and compel the signature on her license. So with that, I will take any questions.
Thank you, Senator. So just to be clear for the committee, New Hampshire is a shall issue state. Is that correct?
I'm sorry, I didn't hear you.
New Hampshire is a shall issue state.
Yes.
Is that correct?
Yes.
So a chief has no discretion unless you are a prohibited person by federal law. They have to give you the permit.
Correct.
Does the permit have a space on it for the chief's signature?
Yes.
So they were not completing the form properly, is what I'm hearing.
Some of the chiefs were great question, and thank you. Some of the chiefs were putting per RSA rather than their signature on it. And boy, I don't know if I get pulled over in another state and I pull that out saying I have a right to have a concealed carry. I'm not sure that would give me the confidence. I wouldn't end up with some legal issues that I didn't want.
Yeah, I would hate to be in Alabama trying to explain what RSA means.
There you have it.
Representative Stone.
Thank you. Thank you for taking my question. During your research for this bill, did you find that this was an ongoing problem with many agencies or just a handful of agencies in New Hampshire?
I don't know the exact number, and it's a great question, but there are some. I did work with the Chiefs Association and worked with them on trying to craft some language that would be acceptable to them. There's still some resistance from some of the chiefs, but they do understand that they have a duty to do, and that the giving, it's clearly spelling out that the immunity in this bill helped ease some of the concerns as they had.
Follow up. In your opinion, in the research you've done, isn't it kind of obligated by their Office of Chief of Police to sign these forms if there's no reason to deny a license?
I felt that was the case, but the court, and again, I'll let my constituent talk about her court case and the court ruling that came through. Essentially, my understanding is the court said that, they have to issue the license, but it wasn't clear that they had to sign it. So we're making it clear that they have to sign it, and that's what compelled this legislation.
Thank you.
See no further questions. Thank you for introducing the bill to us.
Well, you're very welcome, and thank you all for the great work you're doing. Have a great day.
Yeah. And the chair calls Cheryl Dean.
Good morning. Well, I'll just start my story. I already had a signed concealed carry permit issued to me in 2015. And basically what I'm going to go through is just the court case and then the judgment. And I have copies for everybody of both. Because there's exhibits and
Yeah,
whatnot in there.
if you don't have to get into detail if you don't want. You can just give us basically the timeline of what happened and what the judge said.
Yeah, I'm going to give you the Reader's Digest.
Right. And if you want to hand out more in-depth stuff for us to read, we'd be happy to take it.
Okay. So I did have a signed permit, and there is a picture of it in here. I went to renew it, and that was after constitutional carry had passed. So that was in 2019. nothing had changed. I'm not a prohibited person. I'm actually a certified NRA instructor as well as a range safety officer. I have a ton of certificates, and I'm highly trained. So when I went to go get it in 2019, I picked it up. And instead of it looking like the one that I had before, it said, where it has authorized signature, it says per RSA 159 -6. So I questioned it because of it not being a signature and there was no title given on there. I do travel to other states. And like you said before, I don't want to have to explain something in Alabama because it just doesn't look like it's filled out. So I went back and I was like, well, you know, to the chief, I'm like, well, what is this? And he's like, well, per constitutional carry passing, I'm not signing any of them. So I was like, oh, great. In addition to that, there was an issue too. He didn't issue it for the correct number of years. So I got an attorney. The attorney contacted him. We got another pistol revolver license that had the correct number of years, but he still refused to sign it. He worked with my attorney a little bit. So it actually went to court. And the judge found that RSA 159-6 does not require chief signature in order for the license to be validly issued. However, he must include his name as chief of police of Northwood, as it is the chief who has the authority to issue such licenses, not the police department generally. So basically what she said, that the RSA needs to be fixed because there is nothing in the RSA currently that says he has to sign it. So I did get another one. It has his title on it, but it still says per RSA. So all I'm looking for is to have my PRL look like everybody else's and not I get a hairy eyebrow when I do have to show it.
Is he currently still the chief?
Yes.
I see. Okay. And are you aware of any other, in your experience working with firearms and things, are you aware of any other chiefs that are doing this? Is this some kind of a movement or what?
It's not just my chief. There are others. My attorney, Evan Knappen, he was working with a couple other people or had spoken to a couple other people at the time. So I know it wasn't just Northwood.
Further questions? Seeing none, thank you for your testimony.
Okay. Where do I?
If you hand it out down at the end there, they'll pass it around if you have one for everyone.
Great.
If-
Thank
anyone
you.
else? Anyone else wishing to testify on this bill? Seeing none, I hereby close the public hearing. The next public hearing will start at 1 o'clock. So we're on break until 1 o'clock.
Good afternoon, everybody. I hope you enjoyed your lunch. It is 1 o'clock. So we are going to open up our afternoon hearings. And I would just like to remind everybody before we begin that looking at our agenda, it would appear that several of our bills may end up being a little bit controversial. So I would just like to remind the committee, if you're going to ask a question, please just remember to keep your opinions for the executive session, and just please remember to state the question from the get-go. That would be helpful. And we recognize Senator Abbas to introduce his bill.
Good afternoon, everyone. Senator Darrell Abbas. I represent District 22, serving the communities of Pelham, Salem, Axon, and Plastow. I'm here to introduce Senate Bill 248 as the prime sponsor. This language may look very familiar as Senate Bill 252 that this committee passed. I know there was some amendments there, but there were two Senate bills filed at the same time. We felt it was important to, one, on the policy alone was worth passing it again out of the Senate, but also without knowing, when we did pass it, we weren't sure what the status of the Senate Bill 252 would have been, but the original bill, the languages are identical. There is a actual gap in the bail system, the bail laws right now, the procedure. If someone is arrested and if there's if the state would like to request a dangerousness hearing or have someone held because they believe them to be a threat to themselves or to the public, they can request that hearing, but it has to be done. It's a 48-hour notice. So in theory, this person could be held to be a danger to themselves or someone else. However, they've been released into the public or been released by a bail commissioner before that hearing would ever happen. So if you look at the list of offenses, and they're all the offenses listed, all of them there's the two types of crimes. A violent crime where the victim is a human being, or it's a sex crime against a child. Those are the crimes all listed. All of those are egregious offenses. I hope you leave all those in there because they're all serious offenses. Many of those offenses are elevating offenses. Some of those are crimes where the victim never recovers, particularly child pornography. That image never goes away. Once it's out there, it's out there. And the courts have been very consistent when you support that market by simply possessing the material, you're encouraging the activity. A lot of those productions are made overseas, so we can't always necessarily stop that, but we certainly don't have to support the market. Also, many individuals who are charged with that are considered to be dangerous because, one, they tend to not be willing to serve out the offense. You had an issue in Florida where the federal government was executing an arrest warrant for child pornography, and 2 agents were actually shot through the door and died. So these type of offenses, all it's going to do is they're going to be held, and we're not saying bail commissioners are doing a bad job, but they're going to be held until they're brought before a judge. I understand there's a desire or appetite for magistrates. That's something that's, a work in progress. But in the meantime, we shouldn't jeopardize public safety while we work that procedure out. I think this is an opportunity for us to do the right thing and fix that procedural gap. And I hope you all support the ought to pass. I'll answer any questions.
Representative Sytek?
Isn't this duplicative? I thought you said that. So why are we passing this if 318, for example?
Well, stating the obvious, I like my version, the bill that I filed, better than the other one. I wish I also filed first, by the way. But that aside, I believe the bill was actually amended, Senate Bill 252. So this kind of gives you a chance to reconsider whatever was done in that. Also, when we did pass this, we weren't all clear what would actually the outcome of that would be.
I think part of the change was to change domestic violence to felony domestic violence. Can you live with that as opposed to misdemeanor sexual domestic violence?
Can I ask for clarification? Is that the only offense that you want to remove?
I want to remove them all, but I think this is probably the most reasonable one. because I think, in my view, I think a bail commissioner would probably not release I would not release any of these people. And I don't need the law to tell me that, because I recognize that they're a danger. I don't want to preach. The one that is so routine, I've done 500. I'm picking it, and I'm not wrong by much. Misdemeanor domestic violence, where somebody slams the door, pulls a phone off the wall, throws something, and there's no real assault, no bodily injury, no. I didn't say I'm not forgiving or saying it's not serious, but it's a misdemeanor crime, not a felony. He didn't grab her by the throat, throw her around, that sort of thing. So I'm looking to, can you, my question is, can you live with misdemeanor, leaving in misdemeanor domestic violence?
So I wish every bail commissioner would take the position you're taking, but obviously we can't do that. It's a tough pill to swallow. Someone who's represented both victims of domestic violence and people who have committed horrible crimes, domestic violence tends to escalate. It's also one of the most underreported crimes out there. So my experience working on the ground level in interacting with individuals without getting into the details, I would strongly recommend against that. With that being said, would I support the whole bill not passing? I'd have to think about it. But when you said if no assault happens, there's no domestic violence. It's because that whatever conduct they engaged in put that person in fear for their safety, and that's one of the standards. So if they're ripping a phone off the wall and making threats on top of that, and this is an escalating situation, I would be cautious of ignoring that. We had a case in this state where a person was arrested for domestic violence, was released by bail commissioner, and then within that night went to the victim's house, broke in, and sexually assaulted her while her child was in the room. So again, escalating offenses. We're trying to address the most egregious situations that arose from bail reform without really backtracking or erasing the whole system.
Representative Svitek, I feel like we're getting down into an argumentative path. So
That's exactly what I was going to say. I don't want to debate it, but it would be fun.
Thank you. Representative Murray?
Thank you, Madam Chair.
And Representative Svitek's a friend, by the way.
So if I remember correctly, the way we and I was on the bail subcommittee, so the way we amended SB 252 was to remove, like Representative Svitek is saying, the misdemeanor level of domestic violence. But we also lowered the standard for like dangerousness to the public. So instead of it being it's basically in between preponderance of the evidence and clear and convincing evidence. So it also makes it easier for them to hold someone if they are considered a danger to the public. I'm just wondering if you've had a chance to review the bill and like have any thoughts on if this is really needed with the compromise we already arrived to as a House.
So that it's now the legal standard in between clear and convincing evidence and preponderance of the evidence.
It's a substantial evidence, which is supposed to be between those two.
I suppose if you want to articulate a fact pattern to decipher between what would meet one and not the other, I understand lowering the burden. I think the burden of proof is really, I think it's important that the state, if they want someone to be held, in pretrial detention, they should meet their burden of clear and convincing evidence. I think that's fair because the person hasn't been convicted. I mean, there is two sides of it. But when someone's charged with a violent offense where the victim's a person or sex crimes against children, all I'm asking is that bail hearing, that they be held, and sometimes it can be overnight, it can be for a day or two. That's just how our system is right now. I would prefer that to be in front of a judge, because what happens is when people are released by a bail commissioner, the practice is that they waive their arraignment, and then that person is not going to be in court for quite some time. So all this is, that's really what we're trying to do is get this person in front of a judge. That's not even to say the state is going to ask for the person to be held on pretrial detention. That they may agree to personal recognizance. That's up to the prosecutor on that particular case. If they want to go forward with that hearing and the person is held, then the defendant would be able to then challenge that. The procedure is already in the law for that. I believe it's 48 hours. That's the minimum. The maximum time they would have to wait unless they requested more. But more importantly to me is that it's not saying that no matter what they're going to be held. So I think keeping the higher standards appropriate for constitutional issues or like liberty arguments, but at the same time, I don't see the harm in them being brought before a judge.
Thank you for answering my question. Thank you. And so to be clear, the reason why you think this bill, SB 320 or SB 248 is necessary is because we don't know how the magistrate thing is going to play out, and we need to address these issues right now. I guess one concern I'd bring before you that we heard during the subcommittee is the public defenders talking about just their own capacity to, because when it goes before a judge, then they are required to have an attorney, a public defender assigned to them. And under that timeline, it can be kind of hard. And then the capacity increases. So I'm just curious if you've talked with them or if you've heard anything about their almost inability to potentially be able to meet this standard because of the increase in public defenders that would need to be brought in at an earlier point in these cases.
So I think the amount of hearings per day, we did the math last term, so my numbers are a little bit outdated in the sense that they're from more 2022, but I think it was about around 20 to 25 per day throughout the entire state. I understand that some areas will be more populated, but they also have more funding for legal aid in those areas. There are some legislation that's out there to increase funding for legal aid. They're underfunded either way, by the way, so just keep that in mind, that if that comes up in future budgets. But they haven't brought that attention to me. But public safety is public safety. I understand that they may be meeting that client for the first time that day, and if it doesn't go well and the person is not released, they can ask for another hearing within a few days to get more evidence, and they can even have witnesses come in. So, and that cuts both ways, because if the prosecutor is asking them to be held, quite often the prosecutor is also just getting that file that day because the person was just arrested, unless it's an arrest due to an indictment.
Representative Harriet Gathright. You're good? Representative Wheeler?
Thank you, Madam Chair. Thank you for taking my question, Senator Abbas. To hone in on what Representative Murray was saying, it just feels a little bit like Groundhog Day here when we're seeing this bill again, and I'm wondering why file this bill if we're in the process of the House's passed on the consent calendar a number of bail bills, and the Finance Committee is taking them up in a way which suggests they're passing and being moved to your body, in which case you would have the opportunity to amend those and bring them back to us. And I'm a little curious as to why we're creating another vehicle for this issue to be dealt with in the middle of the biennium.
So first, I filed this bill before the other one. That's just how it worked out. 248 just beat my good friend from Manchester to the punch, who's Senate Bill 252. I did ask her to co-sponsor this, but I think it just kind of got lost in the shuffle. So the two bills were the exact identical language. I agreed and gave the blessing, and I testified in support of Senator Soucy's bill passing last year. But we kept this and we re-referred it and held on to it, again, without knowing the result of the bill, the magistrate bill. It never hurts to have two vehicles go in case one falls apart, which can happen based on attendance. I'm sure this body's learned that all too well this term. So regardless of where you fall on that, it does not hurt to have two. But I also think that they're different, because if the magistrate, provisions don't go forward, then you can at least evaluate this on its own form without the magistrate system, and maybe perhaps consider which offenses you want to leave in. I would recommend leaving them all in, but that's a different conversation to have.
I'm all set. Thank you.
Representative Wheeler, there's nobody you can trust better than just yourself, so I might be the reason why people want to make sure that they're good to go.
I believe you had a competing bill as well that you kind of got lost in the shuffle. It just happens.
Representative Muse.
So, just to sum up, one way to think of your bill is as the kind of the before bill, and Senator Soucy's bill, SB 252, is kind of the after bill.
Well, I would say if you pass them both and sign them both into law, they will, from what I understand, would conflict with each other. So that would be ill-advised. But I think assuming one will pass and one won't, would also be ill-advised. So I think if one does not pass and does not make it over the finish line, this is another vehicle to consider because it does address, I think, a procedural gap in the process. I can't imagine someone's charged with, a disgusting sex crime against a child, and the state wants that person to be held, and not released, pending their trial because it's a very egregious offense, and we don't have to get into the specific facts of what that would be. The person could be released awaiting that hearing, which if this is a public safety concern, the person is actually found to be dangerous and there's sufficient evidence of that. It just seems odd that procedural gap is there. This addresses that. Does this solve the entire problems with bail? No, but I think it's a start.
Thank you.
Looks like nobody else wants to ask anything. Senator, you're free.
Thank you, Madam Chair.
Thank you for coming in.
I'm going to be here all day.
David Rothstein.
Good afternoon. My name is David Rothstein. I'm here on behalf of the New Hampshire Association of Criminal Defense Lawyers and speaking in opposition to this particular Senate Bill 248. And sitting here and in talking to Professor Scher beforehand, I'm gathering there's a lot of other moving parts with respect to this issue and with respect to this bill. So some of what I say may not really matter if there's other packages or bills moving forward, but I'm here, so for what it's worth, I'll say what I came to say. This bill, and potentially another one that's moved further in the process, purports to separate out certain offenses for differential treatment based upon the nature of the offense alone, the title of the offense in the criminal code. That is not unprecedented. The federal system does this with respect to bail. In the federal system, there are a number of offenses that are segregated and treated differently and pushed further more toward a presumption of detention with respect to bail. For the most part, these are mandatory minimum firearm offenses, cases where there's a destructive device used, terrorism offenses, very serious drug offenses, also offenses in the federal system that are punishable by up to life or death, such as treason, aircraft piracy, or homicide. So the list, and it also, I will say, the federal list does include crimes against minors, which this list also purports to include. But for the most part, we're talking about some of the most serious offenses that we know or that we hear of. We're talking about Timothy McVeigh. We're talking about people who have a very large amount of fentanyl or methamphetamine facing very, very serious time in prison. Otherwise, the federal system tends to favor pretrial release. The federal system is supported by a very robust pretrial release system where there's a report done on basically every single defendant that comes into the court, and also a pretrial supervision system that's tailored to the circumstances of the individual offender. So what's discussed here is not without precedent, but I think the federal list and the federal system is different in a couple of respects. This separation of offenses for treatment on bail is also not without precedent in our very bail statute. Under RSA 597(1), small c, there is differential treatment already for those offenders who are accused of an offense which is punishable by up to life in prison. In those situations, it is there's a whole different system set forth in the statute. There is a very major burden that has to be met, a much more significant burden that has to be met for a person facing a life sentence than there is for any other type of crime. So we do already have that in our criminal code, in our bail statute, for people who are charged with the most serious offenses. So here we're talking about some offenses that are serious, and I don't mean to suggest otherwise, but are not on the order of homicide. So we have a list, and when we have a list, there's typically a commonality among the items on the list. But this list it has homicide at the head of the list, and it has a number of other types of crimes that, in my view, and in the view of the criminal code, are not reasonably comparable in terms of the penalty and in terms of the ultimate sentence that a person is likely to serve. As you probably know, and as I know well from defending many people charged with homicide, those people generally get convicted. The cases are charged by the Attorney General's office. They're generally very strong cases. If they do not serve life without parole, the plea bargains involved tend to involve decades in prison. So as a practical matter, if this person is charged with first-degree murder, second-degree murder, they are going to serve a very long time in prison. There's a statute that recognizes that and makes it nearly impossible for them to get out of jail. And I think as a system and as a defense attorney, I expect that my client is going to be held and is probably going to serve a very long sentence. So homicide, I think, is the apex in terms of danger, in terms of risk of flight, in terms of the probability of a person being convicted and serving a very long sentence. But many of the offenses here, it's been pointed out that misdemeanor domestic violence is on this list, but even other offenses, frankly, first-degree assault, many second-degree assaults that are on this list, they're often resolved with no or little incarceration, sometimes reduced to misdemeanors, sometimes they end up being dropped altogether, which is a devastating consequence for a person who is held pretrial, potentially more likely to be held due to a presumption. And a person who's charged, I'm just going to pick on second-degree assault, is not necessarily more dangerous to the alleged victim, not necessarily more dangerous to the public, not necessarily any less amenable to release than a person who's charged with DWI, operating after certification as a habitual offender, or burglary. But maybe they are. And this is what judges, prosecutors, and defense attorneys do every day. I will assure you that when a person is before a bail commissioner, when a person is before a judge, that judicial officer, that bail commissioner, absolutely considers the nature of the offense, the Gerstein affidavit, the probable cause affidavit that may be before him or her. If someone is charged with first-degree assault, a light bulb goes off. If someone is charged with forgery, maybe there's a more of a presumption of release, especially if the person doesn't have a record. So I do think this is something that is already very seriously being considered. I do not think that a lot of these offenses belong on the same list as homicide. With respect to offenses against children, which are as abhorrent and viewed as abhorrent as homicide in many respects and for good reasons, currently, I will tell you that there are people charged with aggravated felonious sexual assault who are released on bail. There are people who are not. And the same thing with child pornography. And there's a lot that goes into that sort of calculus. Maybe the sexual assault occurred a very long time ago. Maybe it was an isolated incident. Maybe this person otherwise has bail facts that make them amenable to release in the community. Same thing with the so-called child pornography. Maybe it was one or two images. Maybe it's an especially young or an especially old person. I think all of these things are taken into consideration already. So just in sum, I think that our statutory scheme already sorts things out appropriately. I think that the actors in the scheme can make these assessments. We're not always going to agree with these assessments, and there's always, with bail, going to be a story that can be told about something that happened. And there's not a lot we can do about that unless we just lock everyone up pre-trial. It can happen in any respect. So for those reasons, I would just offer my comments in opposition to this list and this type of segregation based on offense alone. Thank you.
Representative Newman?
This bill, as I read it, thank you, Madam Chair. This bill, as I read it, prevents bail commissioner that on the off hours of the court, this list prevents any of these crimes to be heard by a bail commissioner. So no matter how they keep making it smaller and smaller or bigger and bigger, do you find a concern about the elimination of bail commissioners before we get something else that will take care of the off hours, like the magistrate bill or the judges?
My understanding, and again from talking to Professor Sher, my understanding is that there is, and I've read a bit about a magistrate initiative that is in effect or that is progressing. I've spoken before about bail commissioners. Bail commissioners have been in our system for a very long time. I think bail commissioners they're capable of exercising their judgment. They're capable of exercising their common sense. And looking at the information they have to make the determinations that they make to have off hours. That being said, I always think that we can do a better job. I think judges can do a better job. In the federal system, when a judge makes a bail determination, he's got a probation officer who wrote a whole report to guide him or her in making the decision. So I'm not sure I'm hitting on the center of your question. I think that more training or potentially magistrates is potentially better, but from my position, I have confidence in bail commissioners exercising their discretion with respect to any offense that comes before them.
Thank you. We hear often in this testimony, because we've had testimony on bills like this for as long as I've been here, and this is my third time around. But there's always a premise that's made that the bail commission, that the judges, the bail commissioner don't do as good a job as judges, and more people get released. Have you found that premise that bail commissioners release more people than judges, or what's your opinion on that?
Yeah, I certainly do not have any sort of numbers. My impression is that that's not the case. I mean, it would be, as you probably know if you've sat through a number of these bills, our system is a great system, but it's very deficient in terms of collecting any sort of information. I don't know if states do. I do not have an impression that bail commissioners are more permissive in releasing people than judges are. In fact, I think there probably are a number of different types of bail commissioners in terms of the backgrounds they come from. I wouldn't be surprised if it were more the opposite, where a bail commissioner is going to say, this is a first-degree assault. I don't know very much about this person. I'm not really liking what I hear about them. They're going to get a hearing in a short period of time. I'm going to be more cautious, and I'm going to hold them, or I'm going to set a high bail. I wouldn't be surprised in other words, I wouldn't be surprised if the opposite were in many cases true.
Thank you.
If I may ask a question, so you had mentioned about isolated incidences, and when you had mentioned that, you were talking about sexual assaults specifically. So if a person has this isolated incident, or it may be thought that it is, there really isn't a way for New Hampshire to know if it indeed is isolated, correct?
Correct. I mean, if you have a person, there's all different. Should I finish the answer? Or if not, then I won't.
You can, but that was why I just want to know that there's not
absolutely.
really a way to know if.
You're right. I mean, there's all different types of charging decisions that are made. Right. There are different types. Oh, okay. Thank you. Oh, I'm sorry. There are different types of charging decisions that are made, and they're made after careful investigation. Typically, there's a child advocacy center interview that's done, a forensic interview where a child is interviewed. There are detectives involved who have specialized training. So there's an effort. If somebody if somebody is charged with a single count of sexual assault, there is an effort to determine from an investigative perspective and a forensic interviewing perspective what you have. Do you have a person who committed an isolated incident? Do you have a pattern of sexual assault where you have a girl who's been groomed and sexually assaulted for years? Do you have multiple victims? This is something that I think investigators are always looking at, and I think they're getting better and better at doing it. And when they bring a case before the court, sometimes there's one indictment, sometimes there's 50 indictments. That presumably is going to make a difference in bail, I would think. Okay, sure. Okay, thank you.
Afternoon, everybody. For the record, my name is Albert Schur. I'm a law professor at Franklin Pierce Law Center and an elected police commissioner in Portsmouth. What I say here today is my opinion only, not that of either UNH or the Portsmouth Police Commission. I know this subcommittee, and much of the committee spent 3 months last fall going through all the permutations of bail and trying to put in place common sense, practical changes that address the concerns of all the stakeholders who came in front of the committee. And in fact, all the stakeholders came in front of the committee and came up with a package of bills that are making their way. All of them have made it through the House, the substance of the bills. I think a couple of them are in House Finance. My understanding, they're going to make their way through House Finance relatively shortly and head to the Senate. I think the danger from now on in the package that this committee put together after a lot of work is that one legislator or another is going to see a thread that they think they can improve. If they pull that thread and put another one in, they can make the package that this committee so carefully put together over 3 months of hearings, they can make it better. And I think this committee knows better than anyone. Now, once you start pulling those threads, the whole thing might unravel. There were everybody who testified, prosecutors, the police chiefs, the public defender program, myself, many other superintendents, bail commissioners. Everybody recognized that what this committee came up with involved a set of compromises on everybody's part. I think thread pulling is the biggest danger to something that was carefully crafted, and pulling one thread may unravel the whole thing. I think this committee will understand the significance of what I'm about to say. I'm in support of this compromise, and when I was in House Finance last week, the executive director of the Police Chiefs Association got up and said that the Police Chiefs Association was in wholehearted support of the compromise, what I call the grand bargain. So I don't, you can quibble this way or that way, whether Senator Abbas's bill improves something that matters to him. I don't think it does. I think everything that is in his bill is in the compromise bill and more. I think it's better than this is. And so I really strongly recommend that this committee interim study Senator Abbas's bill. And if for some reason things fall apart in the Senate, then we can pull Senator Abbas's bill back if need be and address it. But let's not be distracted by a particular thread that one legislator or another doesn't like.
Thank you. Attorney Representative Newman.
Thank you, Madam Chair. Thank you for taking my question. This compromise that you speak of that's on its way, Does this solve the problem that occurs when you take bail commissioners away, or is there something, would the bail commissioners remain in the interim, or would there be a blank now because, like this bill, that they would also take away the bail commissioners?
So, it's a great question and captures the multi-layered approach of the grand bargain, the compromise bill. The compromise bill identifies 12 crimes. They're all felonies, a little different than what's in Senator Abbas's bill. And it says they will be held without seeing a bail commissioner, but they must see a magistrate within 24 hours or a judge within 24 hours. Okay. The compromise as a whole does not get rid of bail commissioners. I know Representative Sitek believes differently, but it doesn't get rid of bail commissioners. In fact, it raises the pay of bail commissioners, and in fact, it requires that if the defendant can't pay the bail commissioner, that the state pays the bail commissioner. So we do better by bail commissioners in the compromise bill than anyone has done for all the years that I've been, and some of you on this committee know how many years that is, all the years that I've been involved working with this committee and other committees on bail. So I want to get rid of the misunderstanding that the compromise gets rid of bail commissioners. On certain crimes, it says it meets the needs of police departments who said during all the hearings last year, we don't like these serious crimes going to bail commissioners because we don't trust them. And that's one of the reasons that we put in place the magistrate system, a host of other reasons. It takes care of that problem.
Thank you for refreshing my memory.
Thank you.
Is there anybody else that is here that would like to testify on Senate Bill 248 that has not turned in a pink card? Seeing none, I will close the public hearing for Senate Bill 248. For Senate Bill 414, and we recognize the sponsor. Oh, Representative Senator Abbas to introduce the bill.
Thank you, Madam Chair, members of the committee. Senator Darrell Abbas. I represent District 22, serving the communities of Pelham, Salem, Axon, and Plastow. I'm introducing this on behalf of Senator Gannon. What this does is it creates a mandatory minimum sentence for someone who distributes fentanyl or fentanyl class drug to someone and it causes their death. It's a 10-year mandatory minimum sentence, and they could actually serve up to a life imprisonment. That's what the bill does, and I can answer any questions.
Representative Bolden.
Thank you for taking my question. Is it your belief that this penalty increase would make it less likely that people would overdose?
I couldn't speak on whether they're less likely to overdose because a synthetic drug like fentanyl is constantly changing and being disguised on the drugs. But when it comes to distributing the drugs and you're going to hand it to someone else and it's going to kill someone, I think someone would be less likely to do that, to know that if they did that and it resulted in a death because they're giving someone a drug that has a high frequency of people overdosing and dying, they're going to face a mandatory minimum of 10 years in jail. That's their best case scenario. So I think there would be less people willing to take the risk of distributing it. And I don't believe this would really come up very often when you have two addicts doing hand-to-hands amongst themselves, because, and I'm sure someone with law enforcement experience could explain this better than I can, but generally it's hard to prove who gave what to who when it's in that isolated environment, unless minus a confession.
Follow up.
Thank you. Then I take it it's your impression that a mandatory minimum would be known by people distributing drugs, and they would be less likely to distribute them. I'm just trying to make sense of how a mandatory minimum changes behavior over what we have today, considering that today there is a penalty, someone dies, you are facing jail time. What does more jail time do to that mathematical situation?
Well, number one, they killed someone. They did something that they know could likely cause the death of someone, and then, in fact, results in the death of someone. Is it an intentional kill? Are they intentionally killing the person? I'm not going to go that far, but they're giving someone an illegal synthetic drug that they know has a high propensity to lead to death, and they did it. So perhaps what will they know that they're going to face a mandatory sentence? I can't speak to what a drug dealer would know, but I'm sure after the first person gets a mandatory sentence, it will be well known within the criminal underworld. And I think it's something that we have people dying. Over 400 people died of drug overdoses. 80% of those were fentanyl. And if you're going to give that drug to someone and it's going to kill someone, at this point, I don't see why you don't face a serious penalty.
Representative Harry Gathright.
Thank you for taking my question. So is this bill supposed to be for the dealer, or is this bill directed towards people that do drugs together?
It's anyone who distributes the drug. That's who it would apply to. Now, could it apply to two drug addicts who are, living in an apartment together? Technically, it can. In those scenarios, I will say it's extremely difficult to prove who had what first, especially when the other person's dead. So, although it could be prosecuted that way, that's not the likely scenario. But when you're dealing with someone who's distributing drugs and selling them, and that results in a death, that's what this is targeting. I also point out that when it comes to law enforcement getting informants, well, someone facing 10 years on their head, they may, that's how this works from the ground up.
Representative Knoll.
Thank you, Madam Chair, and thank you for taking my question. Given that fentanyl is ubiquitous, that it is basically in everything, and that we have thus far not passed testing and analyzing, comprehensive testing and analyzing capabilities, how would you demonstrate that someone actually knew what was in there and the amount that was in what they were giving to someone? So demonstrating intent in any way.
Well, it's the intent would apply to them distributing it. Now, they're trying to distribute a drug. If you have what you think is cocaine and it turns out to be heroin, the intent element's satisfied because you're intending to distribute said controlled substance that you believe is a drug that's a controlled substance. What the person's doing is still illegal. The fact that they didn't know how much fentanyl is in there. I mean, we do have testing strips. We did pass that law. But with that being said, they're distributing drugs. We're talking about someone who's dealing drugs that are killing people. And that's what we're worried about here. If someone says, "Oh, I didn't know how much was in there," well, it's a synthetic drug, and it includes the mixing agent. So the reason why people overdose is that it's very difficult to tell how much is in there based on its potency. So that's the problem, and that's why we want to really make a statement that you need to stop dealing this because people are dying because exactly what you said, they don't know what they're doing.
Can I just follow up really quickly? So is the intention to save lives, or is it to make a statement?
Well, it's to save lives by people who are doing this and it results in the death of someone. Now they're in jail. That's one person engaging in behavior that's plaguing our society that's now off the street. So it's when we say we make a statement, what we're trying to explain to the criminal underworld and the people who are doing things that they know will kill people and people who are sick. And I've lost good friends to drug overdoses. So I'm not someone who's not, and I'm sure a lot of people can relate to that. I mean, one of my best friends that I lived with for 5 years in college died of fentanyl. All right, he was an attorney, just like, so no one's exempt here. But the person who gave him that fentanyl, I wish what they really did was ask him to go to rehab or have him call me. But that's not what happened. They gave him a drug and now he's dead. My other friend who died, his wake, I remember his wake was on the day that his fiance's due date was for their unborn child. I wish, same scenario. I wish that drug dealer, rather than give him a drug, did something different. And all that person's going to get is a distribution charge.
I'm going to refrain from.
I think they
sharing
belong in
stories as
jail.
you ask. Thank you.
Representative Murray?
Thank you, Madam Chair. I don't know off the top of my head, so maybe you can enlighten me. If we're talking about, the intent not being death, it's like manslaughter, right? And I was just wondering if there's a mandatory minimum for manslaughter, and is that 10 years?
I don't know the mandatory off the top of my head. It's, I don't believe it's 10.
No mandatory minimum.
Oh. I'll take Professor Scheer at his word, who's not here on behalf of any academic institution. Right? But with that being said, this is a little different than manslaughter because I would put this one step above because you're engaging in behavior where you really know that there's a likelihood or at least a possibility of a harm happening. And then when that harm happens, it's kind of hard to say, well, I didn't mean for that to happen. I think it's common knowledge, even amongst addicts, about the high overdose rates. A lot of drug addicts will not do drugs alone. At least they try to avoid doing that in case one of them overdoses. And that's why we passed a law where if you're with someone who overdoses and you bring them to the ER, that person has immunity. So we're trying to save as many lives as possible on every end of this. But one of the ways of doing that is for the people who are distributing this, there needs to be penalties for it, especially when it results in a death. I certainly would be shocked that they are surprised.
Representative Muse?
So as I look at the statute, a judge currently has the ability to actually sentence somebody who does this to life in prison right now. So what I would like to know is what evidence you have that tacking a mandatory minimum onto a crime that already provides the potential for a life sentence does, in terms of messaging, I guess number one, what message aren't people getting by the fact that the current statute has a life sentence tacked onto it? And the other thing,
I can answer the first
the
part.
other thing I'm curious about also.
One at a time,
is-
Representative Muse, please.
Okay.
So
Okay.
I represented people facing a mandatory 10 to life. Trust me, it weighs on them very much. And that's a very, first of all, that's a heavy weight for them to be carrying. And it's obviously a serious offense. And it's one of those instances where when that's out there, it really puts a stamp on what's happening. When it's a possibility, there's a lot of mitigating circumstances perhaps can come up. What we're saying is when it's a mandatory sentence like this, it's going to be a stiff penalty. And is it going to deter all this behavior? No. But it's certainly, I think, a step in the right direction.
Mm-hmm.
Follow up, Representative Muse?
Follow up, yeah. And I guess the other thing that I'm curious about is what is the case that instituting a 10-year mandatory minimum is actually going to have any impact at all? I mean, have we seen, I know other states have been approaching this issue in a similar way. Have we started to see that those states are actually getting better results by doing this?
I'm not familiar with how many other states have done it because I think that, first of all, when it comes to deaths, there's a lot of, some states are not doing their, as good of a job with Narcan. So some of the numbers can be skewed in different directions. I think our first responders have done an amazing job of saving lives, which is, which is unbelievably, and they deserve a round of applause, but that also mitigates the number down to where it doesn't look like it's as much of a problem as it still is. So I think what we're trying to deal with is the people who are distributing that drug. This is how you bring down these enterprises where they stop dealing the drugs that can kill you from an overdose. Maybe they'll stop lacing it into street level drugs like LSD or cannabis. Maybe they'll stop doing that, knowing that they're going to face a mandatory sentence. That's what's happening, is that fentanyl is getting mixed into cocaine, it's getting mixed into heroin, it's getting mixed into other stuff, and they're not even telling the person that they're selling it to that it's in there. And then the person's dying. So as bad as it is to be selling those other drugs, mixing another deadly drug in there because it's less expensive and it's basically as a cutting agent is problematic. And that's what's causing a lot of these deaths. So we're trying to deter that behavior. If you don't think a mandatory sentence deters the behavior, I'm not sure why we have the penalties in the first place.
Follow up?
Representative Muse, would you be okay if we came back to that if it doesn't get answered? Because we have, I think, 4 other people that still have
It's
their
an
hand up.
immediate kind of a thing, if you don't mind.
Okay, real quick, please.
Yeah. I'm all set. Thank you.
I understand you don't prefer the mandatory result, but mandatory sentence. But if you don't think that's the solution, I'll be interested in hearing what the solution is. I think it's a collective effort of penalties, strong mandatory sentences, also drug treatment, mental health treatment on the other side of it. I think it's you want to take every angle possible, and this is one of the angles.
So just before I continue to go down my list, I just want you guys to know I do see your hands and I'm writing them down. And before we go back around the room, I'm trying to get everybody that had their hand up before we go back for our second round. Representative Stone.
Thank you, Madam Chair, and thank you for taking my question, Senator. In your experience, do we have drug dealers out there still making oodles of money off people's pain and suffering by trafficking in narcotics that they particularly may not indulge in themselves?
That's what's happening. Some use it in themselves and some don't. But they're not only is it causing pain and suffering, it's causing people to die.
Thank you.
Representative Selig.
Thank you very much. And thank you for taking my question. In line 12 or 11 and 12, it says that it's if the death was not too remote in its occurrence as to have just bearing on the person's liability. I was hoping you could clarify what you mean by that, or what the bill means by that.
So my understanding that's the existing law, but I think sometimes when someone takes a drug, if they were to, let's say, die the next day of, let's say, like a heart attack, it's much harder to link that to it. Now, could it have contributed to their death? Perhaps, but that's really something that a medical expert would have to make that determination.
Representative Bolden.
A few years ago, I remember it was a bipartisan legislation was passed into law to forgive or overlook the charge of possession when someone makes a 911 call to report an overdose. But that only applies to the charge of possession and not with intent to distribute. And as I said, that was, I think, unanimously. I think it passed on consent and was a voice vote in the Senate. And so I'm curious how a mandatory minimum on this sort of penalty interplays with the decision-making process when maybe someone who supplied someone with a drug that they're overdosing on is faced with the option of leave and let them die or call 911 and help them, knowing that maybe they would be spared the charge of possession, but could spend 10 years behind bars. What do you think that, what decision do you think people would make in that situation? And how do you think it would play out as far as overdose death rates in New Hampshire?
Well, I would be speculating on what people are thinking at the time, that when they gave someone a drug and then watching the person die right in front of them, how they would handle it. I would hope that they would take that person to the hospital, or at least make an anonymous call or do whatever, use the other person's for just do something rather than leaving them there to die. Could that happen? A good friend of mine's sister that happened to. She overdosed. The person with her did nothing, and she died in that person's apartment. You know, I don't know how those people can live with themselves if that's what they're doing. With that being said, again, if someone were to overdose, it's very hard for law enforcement, and keep in mind the burden of proof for a conviction beyond a reasonable doubt, to demonstrate who gave what to who first. If you have two people using drugs, you know, in an isolated area, for all they know, the person who overdosed is the one who supplied the drug. They don't know that, absent a confession. So it's unusual for that to happen, but they would have immunity, I think, just to the potential of a possession charge. I shouldn't say immunity. I believe it's, I'm going off the top of my head, but any evidence they get during that process where they reported it, the overdose, or brought them to the hospital, that would be, they couldn't use any of that evidence obtained.
Follow up.
Thank you. In my experience, and I think it's limited, I'm not seeing a lot of people in New Hampshire with a substance abuse issue that also have a JD. So if they don't know about burden of proof, they haven't been educated in that, they don't know the exact wording of the law, is there a possibility that hearing about a mandatory minimum would adversely impact the likelihood that someone would call 911, potentially resulting in unsolved, situations where I remember hearing from a Republican lawmaker who was an EMT about finding, bodies in the snow bank outside of the ER, and hearing from police officers about getting a call to a location for an overdose and finding a dead body and a driver's license and the scene had been cleaned. And so, like, looking back on those situations that occurred that resulted in creating the immunity law that we have in place, I guess I'm just wondering, is it possible that the unforeseen consequence of this legislation as proposed would cause more overdose deaths as opposed to reversed overdoses? And would it cause more overdose deaths with no evidence at the scene instead of someone calling 911, getting someone help, and being present and cooperating with police?
I would have no way of answering that accurately because I have nothing to study or information to base that on. I would certainly hope not, because that's clearly not the intent of the bill, is to cause more deaths. I always lean back on, if there's no one selling fentanyl, no one's going to overdose from it. Ultimately, I understand you got to treat people who are addicted. You got to deal with the mental health side of things. There's a lot of pieces here. But if no one sold it and no one distributed it, that solves your fentanyl problem. That's where it all starts. So I think we got to be mindful of that. And for the people that are going to be distributing it, I think that we got to make this a mandatory sentence. Will people not report it? I'm not sure.
Representative Newman.
I have just a question on the wording of the bill, because I've heard testimony about dealers selling. We've got to stop that kind of thing. And it looks like in the bill we've made two changes that kind of make it be what it is. And it changed may to shall. So there used to be judicial discretion and the judge was able to have judicial discretion. And then it says, and maybe you can explain this to me because I'm not sure I understand the phrase correctly, strictly liable. So does that mean that they don't have to be selling it? They could just be sharing the drug with someone, and then someone dies, and then they are subject to this mandatory minimum?
So thank you for the question. Distribution does not necessarily require an exchange of consideration. So if you want to just hand it to people as a gift, that's a form of distribution, which can just as likely kill someone as the person selling it.
Follow up?
Follow up.
Okay. So Is there something in here that says distribution is required? All I see is strictly liable for a death.
Well, I'm using the term distribution, but it says the existing laws manufacture, sells, or dispenses. So it's talking about what happens when you, I'm just kind of summing it up in a general term as
Thank you.
distribution.
Yeah, I didn't see that.
But it's all connected. Someone manufactures it only for someone to sell it, only for someone to then dispense it. That's what's happening.
Thank you.
Representative Harry Gathright, are you good?
Yes and no. So,
Oh.
thank you for taking my question. So if this bill was to pass, would you agree that this bill takes away the discretion of the judges?
When it comes to applying the mandatory sentence, it does limit the discretion because there obviously is a mandatory sentence, but the judge would have the discretion to sentence that person beyond what the mandatory is, up to a life sentence.
Why do you say that? Oh, further.
So someone who's convicted under this,
Yep.
it's a mandatory 10 up to a life. The judge could sentence them to, let's say, 15 years or 12 years.
All right,
That would be within the judge's discretion.
but not less. Oh, sorry. But not less than, correct?
Hold on a minute.
Correct.
Okay, thank you.
Representative Reed?
Thank you, Madam Chairman. This is a little bit off, but relevant nonetheless. We're losing a lot of lives to fentanyl overdoses. Do you think shutting down the border would cut off the supply as well? And perhaps that's something that we should address? Thank you.
I wish we could address that at the state level. I think a lot of the illegal fentanyl comes into this country. It's coming in through the southern border. There's also fentanyl coming in through the northern border. Would that stop this problem instantaneously? It would certainly help because you get rid of the supply. Well, that's a big part of it. If there's no supply, supply and demand, right?
Senator, would this, we have a lot of bills that have to do with fentanyl. We're hearing it nonstop. And we keep on using or hearing the term of harm reduction. Do you think this would be a tool along with the harm reduction if the people are not able, or at least know that there's going to be a serious consequence to destroying families, destroying communities, the state, the country as a whole?
Absolutely. The worst harm you can cause is death. Literally killing someone is the worst thing you can do. And if the people who are causing the death of other people are no longer able to do that, at least they're incarcerated, I think that will ultimately lead to harm reduction. Because if they sell it to me, they'll sell it to you.
Representative Pratt?
Hello. Old friend here. Yes. Could this be called a benefit versus risk bill, where a drug dealer is willing to risk another person's life to make a profit?
Well, I think the drug dealers are doing that now. So they're already doing that.
And this is trying to stop.
And I think that they are aware that what they're doing could cause the death of someone. And they may sell someone drugs, and then knowing that person may share it with amongst their other friends or whatever, and they're doing it anyway. So
yeah, just follow
up.
So this is basically trying to modify a dealer's reckless behavior in the results of a death of another person.
I would call it intentional behavior, but yes.
Representative
Thank you.
Newman, do you have a follow-up?
Yes, I just have a follow-up on, once I found the word sell, I went back and read again, and if you look on line 4, it says all that above, and then it says, or is strictly liable for a death. So does that still include the sale when it says or do I have to rely strictly on the definition of strictly liable?
Thank you for the question. I think what you're asking me is the existing law. But when you say you're strictly liable, regardless of which one you did it, if you're handing it out, you're giving it out, you're selling it, you're trading it, for a sandwich, whatever it is you're doing, if you're the one that's putting it out there into commerce, that includes manufacturing, whatever it is you're doing, yes, you are liable. Whether you intended to kill someone or not, They're saying based on the fact that you did something that caused the death of someone where it is clearly should be on the person's radar. I would be shocked to find a single person that's an adult that would actually believe that fentanyl isn't killing people or could not kill someone.
Thank you.
And if you know how small of amount of fentanyl it is to kill someone,
Yes, I do.
we'll find that on the next bill.
2 milligrams, I believe. Well, Senator, I think that we stirred this soup enough. We're going to go ahead and let you off the hook now. Thank you very much.
Thank you, Madam Chair.
Mr. Summers?
Okay. Good afternoon. My name is Grace Summers. I'm the Executive Director of the Addiction Recovery Coalition of New Hampshire and Milford. I thank Vice Chair Rhodes and the honorable members of this committee for time to speak and testify on this legislation. ARC is a community recovery center that treats substance use disorder at a community level by providing a central location for access to local support systems and peer support services. Our personal experiences with substance use disorder drive our passion and urgency in addressing this epidemic using a peer-to-peer based approach. With so many pathways to recovery available, we guide individuals in finding the pathway that feels most aligned with their values and needs. Prior to this role, I co-founded an in-home addiction treatment company, Aware Recovery Care, and I'm also the former president of Anthem Blue Cross Blue Shield. New Hampshire is currently grappling with a severe addiction crisis, largely fueled by the widespread availability of opioids such as fentanyl and its analogs. However, the proposed legislation, both SB 414 and 415, if enacted, would inflict further harm upon those already suffering the most from this epidemic, individuals struggling with opioid addiction and other substance use disorders. It would lead to the incarceration of citizens who do not pose a threat to our state, but are instead in dire need of support and treatment for their substance use disorders. Rather than spending approximately $68,000 per citizen per year to incarcerate these individuals, I question why we wouldn't allocate these tax dollars toward evidence-based prevention, treatment, harm reduction, and recovery initiatives. SB 414 would inadvertently contribute to an increase in overdoses and related fatalities. Individuals associated with those using these substances will naturally hesitate to be present during drug consumption if they fear legal repercussions. Administering naloxone, brand name Narcan, is impossible while the user is unconscious, further heightening the risk of fatal overdoses. It's instructive to note that New Hampshire has made significant strides in reducing its overdose death rate, which has declined to 13.3 per 1,000 citizens in 2021, after being the third worst state in the United States for overdose deaths in 2016. I do not believe the intent of this legislation is to fill our jails and prisons with some of the most vulnerable citizens. Yet, if these bills are passed, that is precisely what will happen. Instead, I urge this committee to target the dealers and suppliers responsible for trafficking illegal narcotics. Specifically, I propose increasing the quantity of fentanyl specified in Senate Bill 414 to at least 28 grams. It should be noted that many users of fentanyl average 4 to 5 grams per day. I also would implore the committee to look at eliminating mandatory minimum sentences without judicial discretion. We must focus on holding those primarily responsible for the addiction epidemic accountable without needlessly increasing the rate of incarceration for those desperate in need of assistance. It's crucial to recall the failure of mandatory minimum sentencing laws for drug possession, which began during the crack cocaine epidemic of the 1980s. The incarceration rate in the U.S. surged from 100 per 100,000 in 1972 to 760 per 100,000 in 2008, with minimal impact on patient safety. I implore the legislature to take prompt action to amend the quantity of fentanyl and its analogs in SB 415 and to abolish mandatory minimum sentencing. Let us also prioritize allocating funds to support evidence-based and effective addiction treatment, which has been proven to mitigate the impact of addiction and enhance community safety. Thank you.
Representative Knoll.
Thank you, Madam Chair, and thank you for taking my question. I really want to kind of drill down a little bit on what we're talking about when we say dealers. I think people are referring to something beyond the scope of what this would actually entail. So, for example, you were saying the average user, I think you said 4 to 6 milligrams, but I didn't write it down right away. So,
Right. I said some users average 4 to 5 milligrams of fentanyl per day. Yes.
and so my ultimate question is, in your experience working with people who are struggling with substance use, is it common for someone who is in the midst of that to sell to support their own habit?
I mean, anecdotally, that happens on occasion, but typically the folks that we work with, our participants, are the users. They're not selling the drug.
Thank you.
Representative Reed.
Thank you, Madam Chairman. What do most substance misuse people, how do they support their habit? How do most of these people afford their addiction? Thank you.
Yeah, I think it would be speculation for me to say anything definitive. Certainly, some people are employed. Some people have their own financial means to do so, and it varies widely from individual to individual.
Representative Pratt.
Thank you for coming today. I'm asking
welcome.
a question about the number you threw out a minute ago about the 13 per thousand. What was that number?
The you talk about the incarceration rate?
No, I think you were talking about the drug overdose rate has dropped down
Oh,
to
yes.
13 out of 1,000, which is an acceptable rate.
I said the drug overdose rate per 1,000 has dropped to 32.3 individuals as of 2021. The number was much higher in 2016 when New Hampshire had the third worst overdose rate of deaths in the United States.
So if you divided our population of 1.3 million people by 1,000, that would be like over 18,000 overdoses a year.
30. I have to do the quick math. No, it would be three.
I don't have to have an exact number. If we're talking thousands or hundreds of thousands of overdoses, is that acceptable level?
Yeah, I can go back and look at the attribution, but those are the facts as we gathered them.
Thank you.
Sure.
Representative Stone.
Thank you, Madam Chair, and thank you for taking my question. In your experience, do a lot of these individuals that are street level users, do they commit other crimes to finance their habit?
Again, where I come from in Milford, we don't see actually much crime associated with that. That might occur in other areas, but we don't see a lot of it. Does it happen? For sure it does.
Thank you.
Representative Selig.
Thank you, and thank you for taking my question. I'm wondering, do you see any potential to this being for harm reduction, or do you think that those efforts are better spent elsewhere?
From this legislation for harm reduction, I don't see this legislation as engendering harm reduction really at all. I think there's other efforts that would be much better suited for harm reduction.
See no more questions. Thank you very much.
Thank you very much.
Ms. Anderson.
Hello, my name is Lucy Anderson. Thank you for allowing me the time to speak. As a community member, person in recovery from substance use disorder, and employee of SOS Recovery Community Organization, I appreciate the opportunity to submit testimony in opposition to both Bill 414 and 415. 3 years ago to the week, my best friend died of an overdose. He was smart and kind and resilient and a valuable member of his community. I tell you this because I want you all to know how intimately aware I am of the impact drugs have on our communities. Overdose deaths have had an incredible toll on communities statewide, and I know we share a common goal of public health and safety. Unfortunately, the proposed legislation would not make our communities safer, but rather target those most in need of support and evidence-based services. While the goal of mandatory minimum sentences and harsher penalties for death resulting may be intended to target large-scale dealers, that is not what will happen if this legislation is passed. Instead, it would result in the incarceration of individuals working tremendously hard to battle substance use disorder, create better lives for themselves and their loved ones, and, in many cases, simply survive under the unfair circumstances society has created for them. The incarceration of such neighbors would cost New Hampshire taxpayers enormous amounts of money, which could better be spent funding evidence-based substance use prevention, recovery, and harm reduction services. The decision to spend taxpayer money on incarceration rather than quality and accessible treatment and harm reduction supports would be an error, as it would not build up communities, but rather ravage them. Individual punishment does not serve as an effective solution for this communal and societal problem. People who use drugs and/or are in recovery constitute some of our state's most vulnerable and resilient members, and it is our duty to approach this issue with evidence-based solutions. I personally know people who have been impacted by mandatory minimum sentencing laws, and I can assure you that they were not cartel leaders. I also know people who, had mandatory minimum sentencing laws been in place, would currently be incarcerated instead of given the opportunity to become valuable community members. I will never forget sitting with my dearest friend as she was tried for fentanyl possession. Due to the fact that no mandatory minimum existed, the judge assigned to her case was able to determine that she was not a threat to safety, but rather a victim herself. Today, instead of being incarcerated, she is in school pursuing her bachelor's degree and working as a champion for substance use disorder recovery in her rural community. Her story does not have to be unique. I think it is somewhat absurd to sit in this room with the assumption that we are the people who know best how to address this issue. It is people who use drugs that are on the front lines. It is people who use drugs that don't want their loved ones to die the most. It is people who use drugs who are most frequently administering naloxone, otherwise known as Narcan. For these reasons, I urge you to oppose both bills 414 and 415. Thank you.
Representative Selig.
Thank you so much. For people who might be watching or elsewhere, can you just explain what SOS Recovery is? I'm familiar with it, but some people might not be familiar with that acronym.
Absolutely. So SOS Recovery Community Organization is a recovery community organization that offers peer support in a variety of services. So we offer harm reduction support, such as providing safe use supplies, and we offer support navigating the criminal justice system, and it really is everything. On a day-to-day, I can help someone get an ID 1 minute, help them get on a shelter list another minute, and provide safe use supplies the next minute. So I really believe that the funding of evidence-based harm reduction solutions, such as those SOS Recovery Community Organizations provide, would be a better use of our funding.
Mr. Barry.
Good afternoon, Madam Chair, honorable members of the committee. My name is Jake Barry. I'm the Vice President of Policy at New Futures. As many of you know, New Futures is a nonpartisan, nonprofit health policy and advocacy organization. We've been working for more than 25 years to address alcohol and substance use issues in our state. I don't want to repeat too much of what's been said this afternoon, but I do want to stress New Future's strong opposition both to this bill, SB 414, and the next bill, SB 415. Simply put, the data shows that mandatory minimums don't work. They don't deter individuals from using or selling drugs. They don't save lives, reduce costs, or reduce human suffering. To the contrary, mandatory minimums often lead to increased rates of incarceration and greater racial disparities within our criminal justice system. Here in New Hampshire, rather than focusing on criminal penalties, we have worked hard to recognize substance use disorder for what it is, a chronic relapsing condition of the brain that needs to be treated, not one that needs to be punished. We have invested to expand our substance use treatment network. We have prioritized harm reduction principles and systems. We have worked to establish drug courts to try and all for the sake of trying to keep people out of the criminal justice system. Data seems to show that this is working. As was noted earlier, the number of overdose deaths recorded in 2023 was at 422. While that number is far too high, it is down 50 from the year prior. And looking nationally, as was referenced earlier, our fatal overdose rate, which was as high as third in the country back in 2016, fell to 22nd in 2021, the most recent data available. In addition to incarcerating individuals and limiting their access to treatment, we fear that these bills will punish taxpayers and stretch the budgets of our prisons and jails in our counties, which are already stretched to their limits. A recent report from the Council of State Governments shows that it costs our counties an average of $185 to house a single inmate for a single day. Extend that over the 3.5-year minimum sentence required under SB 415, and that jumps to $236,337. Or for the 10-year minimum sentence required under this bill, SB 414, that would jump to $675,250, much of which will fall on the backs of taxpayers. Imagine if we just put a fraction of that money towards substance use treatment and recovery systems and programs for these people in need. It would certainly go a long way to help increase access to treatment and help individuals achieve long-term recovery and to helping our state finally bring an end to this addiction crisis. For these reasons, we urge you to oppose both SB 414 and 415 and vote them ITL. Thank you, and I'm happy to take questions.
Representative Stone.
Thank you, Madam Chair, and thank you for taking my question. So, in your opinion, do you feel that the individual that results in the death of another human being should basically be giving a warning?
No, certainly not. I think that there are many, there are many tools within our criminal justice system to address this now. I think that I would say that it's this is a complicated question. I think that when you're talking about substance use disorder, you're talking about addiction, distribution of drug, many people. I think we all have in our minds the idea of these drug cartels that are coming in and selling in large quantities and targeting people. I think that, when it comes to distribution of drugs, it's not always that easy. It's not that clear cut. I think that this bill, the way it's written, would broadly apply to people who, again, are not selling in huge quantities, but are using themselves or sharing with friends. There far too many people are dying on behalf of that. But some of the people who are connected to this are experiencing, again, addiction themselves. And I think that these are things that need to be treated for their sake, for the sake of their families, and for the sake of our entire state. I think that, again, I think treatment is the priority.
Could you give me your definition of what a street level dealer is?
Oh, there are others. There are others in the room who could answer that much better than I do. I would certainly defer to Professor Scher or others who work more closely with it than me. But I think that, again, in our view, I think that many of us have a certain picture in our mind of what a street level dealer is. But I think that it's much harder to define than that and applies to many people.
Well, thank you for your response.
Thank you. Thank you.
Mr. Burns.
Good afternoon. My name's John Burns, and thank you all for being here and giving me the opportunity to speak. I am the Executive Director for SOS Recovery Community Organization. We have peer-based recovery centers in Dover, Rochester, Hampton. We also provide a workforce development restaurant, social enterprise restaurant in Somersworth. We employ about 27 individuals. And I am a person in long-term recovery with experience with drug use and homelessness. I have a daughter who is in recovery and am a family member. And I am standing here in opposition to both 414 and 415. I think these are harmful bills. I think it's important to look at the human element behind what these policies address, and it's stunning to me that we are talking about mandatory minimums because we've already been down this road. We did this in the 80s. It failed miserably. There's a plethora of data, nationwide data, that showed that all it did was increase overdose death rates, not decrease them. There was no evidence to show that it helped people stop using drugs. What there is evidence to show is that it put more people in prison, and that's it. And did so with wide disparities, because we know that when we look at our drug policies in this country, that there's a disparity for communities of color and those impacted by poverty. And so this increases those disparities because it is the people who are the most marginalized and the most vulnerable that tend to be affected by mandatory minimums. It takes the discretion away from judges and it gives them to the prosecutor, which in turn results in unfair, like if we're appointing judges and we're confirming them and we trust that they're neutral, why do we want to take their authority away and hand that to the prosecution and unbalance the sentences that already exist? And I also think when we look at people who use drugs, we provide harm reduction supplies and services at all of our recovery centers. We do outreach with our homeless communities. You know, when we look at 3.5 years for 5 grams, basically what you're targeting there is the individual who has the car and the license to go pick up their substances. And oftentimes that money is pooled with 3 or 4 of their peers that they're using with. And now they're looking at a 3.5-year prison sentence because they had the car, they had the transportation. It's not unusual on a day-to-day basis for me to work with individuals with daily use of 2 to 3 grams, upwards of 5 grams sometimes. So 5 grams could be what somebody uses in a day. And yet here we are looking at a 3.5-year prison sentence. What they do need is they have a health care issue here. We have a chronic health issue that needs treatment. It needs recovery supports. It does not need more prison time. All the prison time is going to do is create more barriers. It removes access to them receiving any sort of help. And when they're released, they now have a myriad of more barriers to getting well, and increases. And there's evidence to show that for those incarcerated, it is only going to increase recidivism, because what they're going to learn inside of a prison is not going to help them on the outside when they get out. So, you know, these are troubling because I look at the work we do, and at every turn, in order to be funded, we have to prove that what we're doing is evidence-based, and we do. And nothing we do that's funded isn't evidence-based, but yet we move forward policies like this and say we will support them with evidence that says they're harmful. And there's no evidence that can be provided that's going to show this is going to reduce overdose deaths. There's no evidence that this is going to reduce drug use. Deterrence, like this is not a deterrent, and there's no evidence that shows it is. And yet we keep pounding our fists on the table saying, well, maybe if we just increase the penalties, people will listen and they'll stop. You know, I constantly see people that I know facing death resulting, people that I've worked with in our recovery centers. Trust me, if I know them, they're not connected to cartels. These are street level kids, and these are people who are sharing their drugs with their friends. You don't even have to sell to get a death resulting. All you have to do is go buy a bag and share it with 2 or 3 of your friends, and you are now guilty of death resulting if one of them dies. And to the point that was made about the immunity laws in New Hampshire, we do naloxone training on the streets in our outreach on a regular basis. When we tell them, encourage them, part of our training is encourage them to call 911. And regularly we hear from participants, I'm not calling 911, not with those death resulting laws. If I'm using with somebody, there's no way I'm calling 911. And so we encourage them to call anyways and run when they hear the siren, if nothing else, just so that that person gets medical care And we know these are the people that are reversing overdoses. Way more overdose deaths are reversed with public administration of naloxone by people who use drugs than by first responders. And it's terrifying to me that they're scared to call, and that tends to increase overdose deaths rather than help it when we put laws like these in place. So I thank you all for listening and hearing our testimony, and I hope you will oppose both of these pieces of legislation. Thank you.
Thank you, Mr. Burns. Is there any questions? Representative Newell?
Thank you, Madam Chair, and thank you for taking my question. I think a lot of the framing is around harsher penalties being more of a deterrent. So my question is, in your experience working with so many people, not the least of which is yourself and your daughter, is our fear, stress, and shame conducive to recovery? Does that increase your potential for recovery or decrease it?
No, in my opinion, well, the definition of a substance use disorder is problematic or chaotic use regardless of consequences. So our minds aren't worried about consequences when we have a substance use disorder. We're focused on not getting sick, generally speaking. At least that was my experience. I figured I wouldn't get arrested for anything I did. And my chaotic use didn't lead to fear of being arrested, then run if I saw police near me. So.
Thank you.
Representative Bolden?
Thank you. I know that you've been working as an advocate since before this legislature passed into law the immunity when you're reporting an overdose. How could you speak in more detail to how the passage of that affected overdose death rates and how you believe a mandatory minimum would affect the rate of death?
Yeah, I don't know how much the mandatory minimum is going to affect it. I can't help it. I know that. What I do know is that prior to that immunity law being passed, there was widespread what we would call dumping of people at hospital room entries, where you would literally, it was like a tuck and roll. People would just drive by the emergency room, open a door, and push people out that had overdosed because they were so afraid of getting arrested. And they still wanted them to get help, but they were not in a position where they were too scared of an arrest at that moment. I remember people pulling up to our recovery centers out front with somebody overdosing in their car. That's happened multiple times prior to the immunity law, where they would come and they'd run in the door like, "I know you guys have naloxone, right?" And we'd go out and help them reverse that overdose. So, and what I have seen is, as the Attorney General's office focused their prosecutions around death resulting, we have seen that it has had a substantial impact on that immunity law and watering it down to the point that people don't take it that seriously. So mandatory minimums is only going to increase, I think, that attitude and that fear that this immunity doesn't mean anything.
Thank you very much.
Thank you.
Mr. Lothstein?
Good afternoon. My name is Ted Lothstein. Thank you for hearing me. I am here on behalf of the New Hampshire Association of Criminal Defense Lawyers. I've been a criminal defense lawyer here in New Hampshire for 29 years and a member of that organization for almost that entire time. And the first thing I want to say is I understand where the anger that lies behind a bill like this comes from. You know, my wife and I have raised our children to quasi-adulthood here in Concord over the last 22 years, and elsewhere in New Hampshire. And we've traveled around the country and seen the ravages of drugs in cities and here in New Hampshire, and it's really hard, and I see it in my job every day. I understand the sense that, we got to do something big. We have to make a statement, but this is the wrong approach. It's the wrong approach because it just transfers discretion. I mean, these types of bills, the people who support mandatory minimums, which we used to have in New Hampshire and realized were wrong and mostly got rid of, but people who support them want to take away discretion from a judge. But all they're doing is giving the same discretion more to the prosecutor who decides what charge to bring in the first place. In the Senate hearing, a state police sergeant, I believe, testified very correctly, by the way, that death resulting cases are difficult to prove. They are very difficult to prove. Prosecutors tend to prefer low-hanging fruit, things that are easier to prove. Someone in this room asked the question, what are we talking about here? Are we talking about big-time drug dealers, or are we talking about people who do drugs together? And the senator correctly stated that our definition of dispense, distribute just means to give it to somebody else. It doesn't matter if it's people using together. And I think that the other speakers we just heard would agree drug using is a very communal activity, a very shared activity, just like drinking alcohol. People obtain it together, share it with each other, and use it together. And so which case will be the first to prosecute is the easiest, and that's simple. Two people who are drug addicted, friends or acquaintances, one of them gets the drugs using shared money, they do it together, and someone overdoses. At that point, what would a good person do? A good person at that point obviously will call for help and try to save their friend's life. What would a bad person do? Run. Because as the state police sergeant said, it's very hard to prove these cases. When the person stays, helps, and tells the police what happens, it's the good person who will get the 10-year mandatory minimum, not the bad person who flees because they're somehow aware of this law and don't want to get a 10-year mandatory minimum. So it ends up being applied to the wrong people. Again, the prosecutor decides, are we just going to charge a person with possession? Are we going to charge them with distribution? Or are we going to charge them with death resulting? That is 100% a decision made by a prosecutor, often right out of law school, often between 25 and 30 years old, often who has not been married, raised children, and gone, had all the life experiences and heartache we have over a longer period of our lives. They don't have the life experiences and the wisdom of judges. They're also making decisions that are not accountable. When a judge makes a decision, she has to say it out loud or write it down, and you can take it to a higher court. When prosecutors make a decision who to go after with the mandatory minimum, they make their decisions in private without having to state their reasons and almost completely unreviewable. So moving the discretion from judges who can sentence all the way up to life in prison but don't have a floor to prosecutors to decide which people should get 10 years, here's what that will lead to. One is it will lead to the greatest injustices, because again, it's much harder to prove it with a sophisticated person who conceals their tracks than against a vulnerable street-level person who did drugs with their friend and then tried to save their friend's life unsuccessfully. And so the most vulnerable people will be the ones targeted for the mandatory minimums. But the other problem with mandatory minimums is that mandatory minimums cause innocent people to go to prison. And that really applies here because the people who are innocent in these scenarios, they're not innocent of all wrongdoing. They're using drugs. Maybe they're sharing drugs. Maybe they're selling drugs. But again, as the state police sergeant said, it's very hard to figure out and to prove who actually supplied the drugs that killed the person, because addicts have so many different sources and so much, and drugs are just passed around. And so what you end up with is that a person who dispensed, gave, or sold drugs that didn't kill the deceased is prosecuted for death resulting, and they're told by their lawyer, we can take it to trial, but if you lose, there's a 10-year mandatory minimum, and prosecutors use that as a cudgel to get the person to agree to 5, 6, 7 years in prison, 2, 3, 4 years in prison. The same person that for the same crime would have gotten maybe a diversion program, maybe a house of correction sentence, maybe their first felony conviction, but not prison. And so it's a powerful tool it's too easy to abuse mandatory minimums because it forces people into decision making like, well, even though I'm innocent, if there's a 20% chance I'll be convicted after trial and I'm being offered 1 year in prison and I'll do 10 if I'm wrongfully convicted, I guess I'll just say that I'm the one who caused the death. So what happens at that point is prosecutors then say, okay, you've agreed to a plea bargain, we'll remove the death resulting part so you don't have to face the 10-year mandatory minimum, and you will sign up for whatever prison sentence you signed up for under that duress. The New Hampshire Association of Criminal Defense Lawyers opposes both 415 and Senate Bill 415, but my comments would be exactly the same. And I read the sheet that's going to be distributed by Devin Chafee, the ACLU, and the New Hampshire Association of Criminal Defense Lawyers agrees with all those points, and that's why I haven't repeated them here today.
Thank you. The committee have any questions? Representative?
Thank you, Mr. Chair. And thank you for taking my question. I'm curious, so I live in Durham. We have the university. So if we have Joe college student who has come to school with what they believe is a bottle of Adderall that they've picked up from a friend, and they say to their study group, okay, we all need a lot more energy and more focus. I've got this Adderall, we could just share it. So they distribute it, except that they didn't test it because they just thought it was Adderall, and it turns out that it's not just Adderall. And one of their peers dies. Would that, based on your interpretation of this law, would that person then be subject to the 10-year mandatory minimum if it was laced with one of these category drugs?
Yes, and I think the senator correctly answered that question, Representative Selig, that is because it's a strict liability crime, all they have to prove is the person knew they were dispensing a controlled drug. They don't have to know which controlled drug it was. They don't have to know it was fentanyl. It's a very pertinent question because a lot of opiate drugs that are sold in the street now have fentanyl instead of what the person expects there to be. It's awful. They're now sold in pill form so that, the pill resembles like a Percocet, but you don't know, is it opiates in there or is it something else or is it fentanyl? So absolutely, and I think the college setting is the best way to understand this because most of us have been to college, at least for a while. And in that setting, if there's several people in a room and there's a case of beer, we all know that not everybody didn't go out and buy one beer each. Somebody pooled money or somebody just went out and bought a case of beer. That person is the person dispensing the beer, just like in your question, whoever brought in the drug that they thought was, I can't remember what drug you said, but they thought was not fentanyl. That person is the one dispensing.
Thank you.
Any other questions from committee members? Representative Bullock?
I suppose in that vein, could there be complications, I guess unforeseen consequences with this legislation in situations where someone might be caring for an elderly person or someone who, does the bill clarify the difference between illicit and prescription overdoses? Because I know that people with cancer take fentanyl and people post-surgery take OxyContin.
I think, well, the definition of a controlled drug is not prescribed. So I think most of that, if you're saying that the fentanyl was prescribed, I think that would take it out of the issue we're talking about.
Representative Newman.
Thank you for taking my question. The bill as it's written, and I'll just take a little bit of it here, that says shall be sentenced to, the mandatory minimum sentences, shall be sentenced to not less than 10 years of imprisonment. Does that leave room in there for a plea bargain before a trial, or does that wording mean that they would have to go through a trial and then be sentenced and then the mandatory minimum would apply, or does I guess my bottom line question is, does the mandatory minimum apply if they were offered a plea bargain of some nature? Maybe they'd have to go to a lesser penalty.
Right. That's what I was trying to say is that that at the start, the charge to begin with is a death resulting charge. The prosecutor can always offer a plea bargain to just distribution of the drug, possession of the drug, some reckless conduct as a felony, some other offense. And so there's ways to get out of the 10 years. And what these bills do is it just gives that power to a 28-year-old prosecutor who's been out of law school for 3 years, instead of giving it to a judge who's been vetted by the executive council, appointed by a governor, and subject to appellate review.
Thank you.
Thank you.
Thank you.
Devin Chafee. Come on down.
Thank you, honorable members of the committee. For the record, my name is Devin Chafee. I'm the executive director of the ACLU of New Hampshire, and I am here today to testify in opposition to HB 414. I want to start by just putting these bills in context, right? Today, you're going to hear 3 bills that create mandatory minimums for drug-related crimes. I want to just harken back to a point that was made by a previous speaker that recently New Hampshire has very much moved away from all mandatory minimums across the board in its criminal code. And in fact, I've been advocating at the State House for a little over a decade, and there have been very few times when I have seen proposals to introduce new mandatory minimums. Most of the bills I have seen over the years have all been pulling back on mandatory minimums sentences in our laws. And there is, so these bills together represent a significant shift and would represent a significant shift in how New Hampshire goes about administering criminal justice in our system. And there are many reasons, I believe, why New Hampshire has chosen not to go forward with across the board, like many mandatory minimums, especially in the drug context. And I do want to highlight that support for reducing mandatory minimums has historically come from both sides of the aisle. And I would never speak for another organization, but I do think it's worth noting here today that both the New Hampshire Liberty Alliance and the Americans for Prosperity both opposed these bills in the Senate. So these are two fairly conservative, traditionally considered conservative organizations who opposed these bills in the Senate because of the mandatory minimums. And the reason why there's historically been this opposition to mandatory minimums is New Hampshire is, I think, fourfold. 1, they are expensive. 2, they are ineffective. 3, they're sort of a one-size-fits-all form of justice that don't take into account the particulars of a given case. And finally, they've transferred judicial discretion away from the judiciary and to prosecutors, as was described earlier. Now, I'm going to dig more into some of these points and when I testify on HB 415 in a moment. But for right now, I really want to focus on the particularly egregious aspects of HB 415, which is, of course, creating a 10-year mandatory minimum for death resulting, which, as has been discussed, is a strict liability crime. You don't have to know what you are passing to another individual in order to be subject to this mandatory minimum. And it's a crime of essentially passing drugs to someone else who then dies of an overdose. And I know that the senator in presenting this bill says that, well, he thinks it's unlikely that the folks that are prosecuted under this law are the friends or the loved ones of the person who eventually dies. But I want to tell you that there has been a national analysis of the prosecutions under death resulting laws across this nation. And the conclusion has been that it is not drug dealers that are primarily prosecuted. And when you think about it, that shouldn't be surprising, because drug dealers don't stick around long enough to get picked up by the cops and associated by a death. Instead, what we see here, and this is, again, there's been studies of these prosecutions, that show this. In many of these deaths, we're talking about individuals who are friends and families of the deceased, oftentimes themselves struggling with a drug use disorder. And I really encourage you, there's been a podcast on this in New Hampshire cases specifically, and to read some of the bios of these cases because it is heart-wrenching when you read these cases. We're talking about friends who go to jail for over a decade because they were using together, because they were afraid to use alone, right? There are people, a husband whose wife bought heroin and then asked her husband to please inject her with that heroin, and her husband was prosecuted under these laws. A wife whose husband asked her for some prescribed liquid methadone to help him fall asleep, who then passed in his sleep. And the wife, woke up and tragically her husband had passed. So these cases I would put before you are the definition of why judicial discretion is so important to make sure that the punishments that are meted out under our criminal justice system actually line up with our understanding of what is just. Moreover, and this I cannot emphasize enough, there has been a lot of studies that demonstrate very clearly that death resulting laws and more mandatory minimum sentences do not reduce opioid deaths, they do not reduce drug use, and they do not reduce crime. And I've extensively cited these studies, and I'll pass out my written testimony in a moment, and you can look at those citations. But if you look at a particular study of drug-induced homicide practices in the jurisdictions of New Jersey, Tennessee, North Carolina, Illinois, Louisiana, and New York, it demonstrates clearly that despite dramatic growths in the drug-induced homicide prosecutions, death-resulting prosecutions, all jurisdictions experienced significant increases in overdose deaths in that same year. What has worked instead in New Hampshire, and this was discussed before, were the laws that you all have passed that have actually allowed greater availability of naloxone that has resulted in the decline in overdose deaths. And I just want to end my remarks because I want you to know that the pain caused by overdose deaths the pain caused is not lost on me. Those deaths are unspeakably tragic, and they cause unimaginable pain and anguish, and I can relate to that. In 2020, I lost my cousin to an overdose, somebody I was very close with, and I grieved with his mom and dad and with my family, and so I understand just a sliver of the pain that is caused by these deaths in our community. And I have to say that personally, when I think about my cousin, what I wish for a friend or a girlfriend or a co-user even of my cousin's to be jailed for 10 years as retribution for his passing, or is what I really wish that he wouldn't have been using alone, that somebody had been there with him who had Narcan and could have saved his life. And I have to say that for me, the answer is clear. And for that reason, I respectfully ask that you recommend inexpedient to legislate on SB 414. Thank you so much for your time.
Thank you, Ms. Chafee. Is that it? Is there anybody else here that wishes to testify that has not turned in a pink card? Seeing none, thank you very much. We'll close the public hearing on Senate Bill 414. And before we open up the next hearing, does the committee need a 7-minute bio break? Okay, so we just came back from lunch before we started our afternoon session, so we're going to take 10 minutes, hard 10 minutes, just to recess them, and we will open up the next hearing. Welcome back, committee members. We are now opening the public hearing for Senate Bill 415. And Senator Abbas, you're up again.
Thank you, Madam Chair, members of the committee. My name is Senator Daryl Abbas. I represent District 22, serving the communities of Pelham, Salem, Atchison, and Plastow. I'm here to introduce Senate Bill 415, which will increase the penalty for certain fentanyl-related offenses. And I heard some members of the public addressing this bill before the hearing opened when they were testifying on the last hearing, but I can tell you for sure that if you have 5 grams of fentanyl or more, there'll be a mandatory 3.5 years in jail. If you have 28 grams or more, then you will face, I believe it's 7 years in jail. It's a mandatory minimum sentence. 5 grams, I hear drug treatment, rehab, mental health. 5 grams of fentanyl is approximately 2,000 to 2,500 lethal doses of fentanyl. If you are an addict and you are carrying that much of that drug around, one, you're an extreme danger to yourself, but it's unlikely that you're just a simple addict just using drugs to get high. That is enough to kill every elected body person in both the House and the Senate and the whole building. So when I hear that this is the substance abuse, this is someone who's dealing drugs. You can make that leap or presumption. So that's what we're addressing. So if you have 5 grams of fentanyl on you, or you have over 2,000 lethal doses of fentanyl on you, you're going to face a mandatory sentence of 3.5 years, because I believe that you're dealing drugs, and that's what it is. Now, if you have 28 grams on you, I'm not going to even break down the math, but clearly that person's dealing, because that person has 5 times the amount as the other person so it's about 10,000 to 12,000 lethal doses now, right? So that's a mandatory sentence as well. This person is selling a drug, distributing it throughout the community, and it's killing people. I heard someone say that the addicts and dealers or whatever are better at saving the lives than the first responders. Well, these people wouldn't be dying and overdosing if not for the dealers. So maybe if they're better at reviving them after they give them something that almost kills them. So that's all right. They're there. So they're already there. So perhaps they're able to do it. I appreciate them trying to save the person's life, but they're still distributing a drug, killing people. And I think we got to put a stop to this. And one way to do that, if the person is in jail, they're not selling this on the street, killing people in the state. Simple as that. So please, hope you support the ought to pass, and I'll take any questions.
Do you have a question, Representative Murray? I'm sorry. Representative No.
Thank you, Madam Chairman, and thank you for taking my question. I'm wondering about, we often give these statistics about how much will kill the average person, or how much is a lethal dose. But there's also the concept of tolerance, not to get into a story.
Please don't.
I
Question.
won't. I know. I'm saying. But that contributed, the lowering of tolerance based on someone taking Vivitrol contributed to the death of someone I love very much. And so my question is, when we
loss, by the way.
Thank you. When we talk about these statistics on how much will actually kill someone, and yet someone else talks about people doing an average of 4 to 6 grams a day, some people, that to me indicates tolerance. So how does this account for the tolerance that someone might have built up in their use over time?
So two parts to this. Number one, if you have a cutting agent, that can create a higher amount. So if you cut the drug, which if someone's cutting the drug, it's also fair to say that they're a dealer. Now, when someone overdoses, there's a lot of things that will come into place. Their overall health, someone with, a poor respiratory system is more likely to overdose, at least die from the use of opioids. The body weight would matter. If they have asthma, that would matter. There's a lot of things that get factored in, and their tolerance level. So
can I
and
follow
also
up on
it depends on how they actually take it sometimes as well, whether it's injected or if it's, there's a lot of different ways to do it. So there's that. This doesn't factor it in, but what I would tell you is that the 5 grams of fentanyl that's not been diluted several times over is enough to kill a lot of people. Now, when I say it's between 2,000 and 2,500 lethal doses, I'm basing that on what the federal government has reported. So it will vary from person to person. If everyone took the same dose, yes, not everyone will overdose, but that's the belief that the approximate lethal dose is about 2 milligrams.
Follow up? Just quickly, what I'm trying to get at is that there are many factors that contribute to the potency and the harm that something can do, but this doesn't take that into account, and that's okay.
Well, I think it does, and to extent that, I mean, when you come up with what the number should be, if that was 3 grams or 1 gram, I mean, 1 gram is still lethal doses, but at the same time, 5 grams is when I say 2,000 lethal doses, again, I'm not sure what someone's doing with that unless they're selling it. That is highly unlikely to be for one person's individual use.
Representative Newman.
I'd just like to thank you for taking my question. I would just like to clarify the line beginning on line 19, where it says, well, it says 5 grams or more, including any adulterants or dilutants. So is it 5 grams of killing level heroin, or how much of it has to be, not heroin, how much of it has to be fentanyl and the rest be dilutants, but it comes up to 5 grams? Where's the differentiation in there?
And thank you for the question. I'm really glad you asked that question because I encountered that in a trafficking statute a little south of the border. And the mistake the legislator made in Massachusetts is one of the inspirations of why I ran for office, because the fentanyl trafficking statute was not drafted correctly, which made it impossible to convict someone of trafficking. It has since been fixed, by the way. But so because it's a synthetic drug, you have to include the mixing of the cutting agent, because literally a grain of salt would change the ingredient because it's an artificial drug. So you really, when it comes to any drug, whether it's cocaine, heroin, fentanyl, you have to include any dilutants that may alter the weight. But when you're dealing with a synthetic drug, it can create something all different altogether. So you really need to, if it doesn't include that, it's really hard to prove purity with a synthetic drug as opposed to like cocaine or heroin. That's natural drugs, I would say.
Follow up?
Follow up.
So how does that affect the statistics that you gave out about 2,000, all the people in the legislature and everything? How does that affect those statistics, or does it?
Well, I'm basing it on what the federal government reported. So I relied on that information. I hope that the information they're putting out there about fentanyl is accurate.
Thank you.
Representative Murray.
Thank you, Madam Chair, and thank you for taking my question. We heard during testimony on the previous bill, and I think I've seen in this committee, that we are moving away from mandatory minimums in general in the criminal code, and relying more on giving the judges, the ability to decide what they think is the appropriate sentence. And I'm just wondering if you have any specific reasoning behind wanting to bring mandatory minimums into this part of the criminal code. Are you observing judges regularly sentencing people to a shorter time frame than this, or is this just something that you think will help? I'm just curious if there's anything behind that.
Sure. So the war on drugs, I understand where there's some strict mandatory sentencing. It had some of the statistics that came out suggested that it wasn't the best approach. But when we're talking about simple possession charges, I understand why that's not a mandatory sentence. So, simple possession, that is a drug addict. That is someone that needs help. I understand that. There's a lot of things that can contribute to why that person is in that situation. Untreated mental health issues, or even if they're getting treated for mental health issues, they could have suffered traumatic events. There's a lot of things that contribute to that. It's the drug dealers that are the problem here. If there were no drug dealers, the overwhelming majority of this problem would be gone. It wouldn't exist anymore. You would have some very small problem here because not only are they infecting people who are addicts, they're literally they're in the sales business. They're seeking out new people to sell their drug to create new addicts. The other problem is when people get out of rehab or they get out of jail, they go right back in the same circle of friends who are many are addicts. And I had a friend, he was sober for 3 months, and he actually started putting on some weight. He was real frail from his drug use. And when he was getting rid of some of his old clothes, he found something in one of his pockets that was kind of left over. He was right back to it, and he's still an addict today. So it's pretty sad how easy it is for someone to fall back off the ladder that quickly. Even though that was not a drug dealing thing, the dealers, this focus on the dealer, and that's what's leading to the deaths. That's what's leading to these further problems. And the people who are relapsing, a big part of it is the dealers. And if you have this much fentanyl on you, I don't think it's unreasonable to assume that you're distributing it.
Follow up. Thank you, Madam Chair. I guess I'm not quite referring to, treating dealers differently than those who are just possessing, but more like mandatory minimums as a tool. Like, have you seen judges regularly, in their discretion under sentence, in your opinion, in these cases that you think it's necessary to create a mandatory minimum?
So I wouldn't say I observed an individual judge. When it comes to sentencing, there's so many factors that go into places. The first offense, do they have just a prior criminal record? Sometimes it's pled down from like a higher charge to a lower charge. So it's really circumstantial. And keep in mind, this is 5 grams. Let's just say you had 27 grams. So you just missed that 7-year cutoff. That's a bigger deal than if you had, let's say, 6 grams. So I think there's a big part of it is a lot of the other circumstantial things that can go into this. Also, it's the strength of the case. When sometimes they enter a plea that may play an impact. There may be some evidentiary issues we don't know about. So there's so many things that go into sentencing. What I will tell you, living on the border of where Methuen and Lawrence is, Lawrence is, it's been titled the fentanyl hub of New England. If people want to engage in behavior south of the border, I can't control that. But in my district, right along the border, for someone who represents criminals, they're well aware of when they're in what jurisdiction they are and what the penalties are. And my source is very reliable.
Thank you.
I should say sources.
Representative Selig.
Thank you, and thank you for taking my question. I'm in Stratford County, where we've had tremendous success from our drug courts. And so this seems to be the kind of thing that would take diversion programs like that away as an opportunity. And I'm just wondering, in certain cases, for example, we had testimony previously that it may well be someone who's just pulled the funds because they had the vehicle to go pick up the stash for their group of friends. And so where someone might be better suited by going into a treatment program and through the drug court programs, I'm just curious how you see this as being able to balance with that.
So if, let's say there's a group of 4 friends, one of the 4 goes to buy a large amount of fentanyl for the group of 4 and it exceeds the 5 grams, and how that would impact them, at least their eligibility for the drug court or drug diversion program. If that's the case, one, they're still distributing fentanyl, which could lead to their friend's death. So there's that issue, but there's also some discretion of the prosecutor in how they want to handle that. But if they're going to have over 5 grams and they get caught with that amount, I mean, again, they're gathering this and they're distributing, and that's my whole point, is that they're not just using this for personal use.
Yes, but please just ask the questions, okay, Representative? You're welcome.
To clarify, so you would give the discretion to the prosecutor and not to the judge in that case?
Well, this bill would not do that. What I'm saying is the prosecutor could, in their discretion, offer to reduce the charge as part of the diversion program. That happens frequently, especially with someone who has, a lighter record, shall we say. Someone who has kids, if they're working, they're gainfully employed. Sometimes it's, if someone's not working and they have all this money, it's pretty, again, they can kind of put it all together. It's not rocket science. But if a person has, some other circumstances going on, that the prosecutor may be more inclined to offer that. Also, again, the strength of evidence. There's a lot of things that go into it. But I don't think it would completely prohibit them from being involved in it. It just, again, but I think the example you used, it sounds like they're distributing fentanyl still.
Representative Stone?
Thank you, Madam Chair, and thank you for taking my question. In your experience, when involving what we call drug dealers, and the state builds the case, is it usually one occurrence of a sale, or is it usually multiple sales before the actual charges are brought with a intent to distribute or possession with intent to distribute?
So it's both. I mean, the larger ones are usually the subject of a much large investigation. There's a kind of like an enterprise or going on with several. That's usually done with a lot of different law enforcement agencies involved. When it comes to like stuff like this, usually your lower level dealers, that's usually sometimes they can target the person, but sometimes it can be as simple as either they know the person has been involved and has a prior history, and they kind of can then see they're going to an area where it's known for drug trafficking and engage in behavior that way. Sometimes they witness hand to hands, and sometimes they don't. When they search the person after they arrest them, when they observe the hand to hand, the person will have a large quantity on them. Sometimes it's when drunk driving arrest can lead to these, so it can be a lot of things that kind of can invoke this type of charge.
Thank you. Follow up. In addition, prior testimony you gave was that certain individuals might be inclined to become a cooperating individual if they do have a charge. And obviously, if you're in the game, then you can cooperate. If you're not in the game and it's an isolated incident, you don't have the connections to work. If that's involved, does that usually kind of hinder their ability to continue with their course of business?
Well, it depends on how the cooperation agreement is working. What I'm just saying is when a person's facing a mandatory sentence or a strong penalty, that is one tool that law enforcement does use to get there to get an informant. And that's how they go up the ladder. So when you talk about those larger drug operations, to get to that point, it usually starts lower down the list.
Thank you.
One question. I mean, your bill, I mean, we seem to be defining a drug dealer by the amount of drugs that they happen to be caught with on their person. Isn't it more complicated than that?
Well, it's an illegal drug. The person has 2,000 to 2,500 doses on them. That's can be a lethal amount. If the person's just simply an addict, I mean, they're buying in bulk for how long now? It seems to me that when someone buys in that large quantity, you can use that as a presumption to assume that it's one intent to distribute. You can use it as a presumption to assume a lot of things. And I think in this case, if you have that large of a quantity, it's implying that you're beyond just a simple addict. I understand that it's not that you can't. I don't think it's fair to compare that to other drugs. Or if someone has a large amount of marijuana, like they have like a half a pound. Some people buy in bulk, I guess, but even then, you can make the assumption that the person's dealing that illegally. It's how it's packaged can often lead to that assumption as well. But again, when you have that many doses, I mean, that's an incredibly high amount. I mean, if there's an addict, they can explain why they have that much on them. They usually don't go out and buy that much because it's a money factor too.
Follow up? Yeah. So one of the things about mandatory minimum laws is they don't give judges a great deal of discretion when it comes to things like that. So it would seem that just the very fact that you had that amount of drugs that were connected with you in evidence is just prima facie evidence of the fact of your guilt. So does anything else come into play in a situation like that? I mean, you're a defense attorney. How would you defend somebody?
If they had over 5 grams on them?
Yeah. How would you do it?
Well, the search and seizure is usually the best way to go about it. And if that's lawfully and the test comes back as it is, sometimes it's what it is. Johnny Cocker himself would run into a a wall if that's the case.
So no defense.
I didn't say there's no defense. Possession also matters where they found it. So if let's say it's in the car, you can defend it other ways. But if it's in their pocket and the search is constitutional and it exceeds that amount, I mean, there's only so much you can do. Beg for mercy, argue for mitigating to try to get them into diversion program. That's the next step. But you can't make something out of nothing. But when it comes to this mandatory, I guess I'm trying to figure out, if you don't think a mandatory sentence is appropriate, what is a person doing with that much fentanyl without facing any type of harsher penalty? Do you understand that fentanyl on this table, if there was fentanyl on this table and I touched it, I could overdose simply by just touching it inadvertently. So that's an incredibly large amount that no one should have on their possession, period. Never mind, even if you're just an addict, that is ill-advised on every level.
Thank you.
Thank you, Madam Chair. I'm going to follow up to Representative Muse. If you're in a situation that you just described and you're the defense counsel, that's where you would hope to try to negotiate with the prosecutor for a plea deal, which would take the mandatory sentencing off the table at that level, correct?
I would certainly try, especially knowing knowing I'm an uphill battle. I mean, again, sometimes you file that motion and before it's ruled on, that's sometimes the best way to, work things out. There's so many things that go into that. And again, the person's background, their prior history. Again, they may have had 6 grams or 5.5 grams, but if they had 27 grams, it's more, even though it's the same offense, it's still egregious. That's what you would have to do. I mean, you reach a point where there's only so much you can do on a possession case.
And just to follow up, the prosecuting attorney would have some discretion on offering a plea deal.
Yes.
Thank you.
Thank you, Senator.
Thank you, Madam Chair.
Ms. Chafee?
Thank you. Sorry about that. Again, my name is Devin Chafee, and I'm the Executive Director of the American Civil Liberties Union, and I am here to testify in opposition to SB 415, which creates mandatory minimums for certain fentanyl-related offenses. And I want to take this opportunity here to really dig in a little bit further into why New Hampshire law does not include mandatory minimums, especially for drug-related cases here in New Hampshire. And as I stated earlier, this is because they are expensive. They are a one-size-fits-all approach to justice that fail to take into account the particulars of a given case. They transfer judicial discretion away from the judiciary to prosecutors. And perhaps most importantly, they don't work. We have been down this road previously. We know that they don't work. The data is in. I want to start by just elaborating a little bit more on the tremendous cost that mandatory minimums put on taxpayers and would begin to put on the taxpayers of New Hampshire if New Hampshire were to go down this road of leaning towards mandatory minimums. And in doing so, I want to quote Grover Norquist, which is interesting for a representative of the ACLU to be quoting. For those of you who may be young and do not know, he was a longtime tax reduction advocate and a founder of Americans for Tax Reform. And Grover Norquist has stated that the biggest problem from the perspective of the taxpayer is that mandatory minimum sentencing policies have proven prohibitively expensive. He went on to cite the skyrocketing costs of incarceration to American taxpayers, saying that this explosion in costs is driven by the expanded use of prison sentences for drug crimes and longer sentences required by mandatory minimums. And he stated that it appears that mandatory minimums have become a sort of poor man's prohibition, a grossly simplistic, ineffectual government response to a problem that has been around longer than our government itself. And viewed through the skeptical eye that I train on all other government programs, I have concluded that mandatory minimum sentencing policies are not worth the high tax to Americans' taxpayers. And so I would just put to you that, we have been down this road before. We know that mandatory minimums do not work, and they come at a very high cost to the state and to the New Hampshire taxpayers. As has been discussed, they also take discretion away from judges and they give it to prosecutors. Now, this has been described at how this happens by some of the defense attorneys behind me, but I want to also put forward that this issue of taking power away from the judicial branch and giving it to the executive branch through mandatory minimums actually has constitutional concerns as well, separation of powers concerns. And here I'd like to quote David Keene, who's a prominent gun rights advocate and was an advisor to the George H.W. Bush administration. And David Keene stated that my opposition to mandatory minimums is rooted in conservative principles, namely reverence for the Constitution and contempt for government action that ignores the differences among individuals. James Madison, for one, believed that a clear separation of powers was more vital to protecting freedom than the Bill of Rights. Yet mandatory minimums undermine this important protector of liberty. The attempt by legislatures to address perceived problems in the justice system by transferring power from judges to prosecutors and the executive branch violate these principles and have in the process given prosecutors unreviewable authority to influence sentencing through their charging decisions and plea bargaining power. Additionally, I want to flag that mandatory minimums do not work. We have seen them in play previously, whether it be in this state and across the country. And we know that aside from anecdotal accounts, there is no statistical evidence. And I will note none that was cited by the sponsor or the senator who introduced this bill. No evidence, despite decades of experience with mandatory minimums, that they have any significant relationship to reducing crime or reducing drug use. And in fact, in a 50-state study, found that there was no relationship between drug sentencing and 3 drug epidemic indicators: illicit drug use, drug arrests, and overdose rates. So we do not see mandatory minimums having any impact whatsoever on crime rates, drug use, or overdoses. Moreover, mandatory minimums may actually increase the likelihood of recidivism because harsh mandatory minimum penalties serve to increase the length of time in prison. And studies have noted that there is a relationship between longer stays and recidivism. And for these reasons, I respectfully request that the committee recommends HB 415 inexpedient to legislate. Thank you very much.
Representative Pratt.
In response to that, I have a question. Do you think somebody sitting in jail for 10 years can kill somebody by giving them a drug dose?
I'm sorry, I'm not sure I understand your
So
question.
if somebody is sitting in jail for 10 years from a mandatory sentence, do you believe they can kill somebody by giving them more drugs?
What I have seen, what I do know, and what I have seen through the data and the analysis that have been done is that there is no demonstrated data that mandatory minimums actually reduce drug overdoses. And that's just, that's the evidence that we have seen. And that is why states like New Hampshire have shifted away from mandatory minimums as a way to address the drug crisis in our state.
So that doesn't answer my question. So the person that's sitting in jail, can they now sell another lethal dose to another kid?
I don't believe so, unless they
No.
have access to
They
those,
don't.
unless they have access within
don't.
our facilities.
Thank you. Thank you.
Let's just not argue with our people that are testifying, please. I know, but let's be very careful. We're going down a slippery slope. Thank you, Representative. Are there any other questions? We're all set. Thank you very much. Burns?
Good afternoon again, and thank you for allowing me the opportunity to speak. I want to reiterate all of the points, and in the interest of time, I'm not going to sit up here and repeat all of them, as pretty much all of my points that I made about SB 414 are the same for SB 415. But I do want to look at the dehumanization of the people that we work with and that the people this targets, because with all due respect to the senator that presented the sponsorship on this legislation, he stood up here and referred to people who use drugs and people in recovery as addicts, which is a very stigmatizing term. And this is the strategy that's often used by law enforcement and drug policy, is to dehumanize people, demonize them, label them. My daughter is not, he used the term simple addict versus people who have 5 grams. And I work with these people every day, and they're a lot more than that. And it is not unusual to see people with those quantities. And I think, talking about 0.1, 1 milligram being a deadly dose, the reality is, when we look at street level front lines, some of his testimony was out of touch with what I see. So on average, to give some education on that, what we usually see are what we call 20 bags, 40 bags. Occasionally people buy it by the gram, or higher level as a finger, what's called a finger on the streets, which is 7 to 10 grams, depending on where you're at. The street value of 5 grams generally runs $400 to $500. So we're not talking about massive quantities here. And it's not hard for somebody with 4 or 5 friends using drugs to grab that, to pull together that much money, and face a 3.5-year mandatory minimum as a result now with this legislation. And again, kind of what I said before with the licenses. But I also want to remind this committee that when we're talking about these people, these are our kids. These are our friends. Not everybody, contrary to what the media portrays, these aren't all under bridges. These are people who are in our workforces. These are people who are functioning oftentimes that are being prosecuted around this. And oftentimes we've heard the stories numerous times. These are people who may have had an injury and were prescribed opioids, and this led to this. We know how this epidemic started, and it impacts people that look just like us in this room all across the state. And those are the individuals that are going to be targeted with this law. And those are the people that are going to be locked up for 3.5 years without, and I think when we look at the balance of power with judicial discretion too, I think often these laws are misdirected and end up coming after the people that we don't intend them to. So the big fish, so to speak, go in front of get arrested, and they tend to be talked into flipping on a couple of their smaller fish. And those smaller fish are the ones that end up facing a mandatory minimum of 3 years, while the larger fish that we had hoped to target with these laws run off as a criminal. They might be a CI for a period of time, face less consequences, while the people that have less resources to get the representation they need are targeted in this. So oftentimes, as I say, if somebody's involved with the cartel that we're trying to target here, chances are they're not touching the drugs and they're not in New Hampshire, because it's those big fish. They don't come into contact when we're looking at street level dealing. And most of the people that I see that are dealing in quantities of this nature are people just like us who have struggled with a substance use disorder and are actively using, and they're sharing it with their friends. So I just want to reiterate those points and realize that what we're talking about here are not grizzled criminal cartel members. These are people in our community. These are people like my daughter, people like the people I work with every single day in Rochester, Dover, and Hampton. Those are the ones who are going to be locked up in a prison cell for 3.5 years without the opportunity to go to treatment court, without the opportunity to receive diversion, without the opportunity to have any sort of support for a substance use disorder, which should be looked at as a healthcare issue, not a criminal justice issue. I don't know when we walked away from the we can't arrest our way out of this notion. But it's really unfortunate to see the pendulum swinging this way. And Representative Pratt, if I could just respond to, yes, absolutely. If somebody's locked up for 10 years in a prison, they are still going to have the opportunity to sell drugs, because there's an entire underground market in every prison and every jail that I've ever seen in all of my work, and we have a statewide criminal justice program. So unfortunately, drugs get into prisons too, and so we're not keeping any sort of trafficking outside of prisons. And I'm sure most of the correctional department would attest to the fact that they struggle with this. That's why we have overdoses in prisons, and that's why they're getting naloxone for the prisons. So, thank you.
Thank you, Mr. Burns. Do we have any questions? Thank you very much. Mr. Summers?
Good afternoon again. Thank you very much for the opportunity to testify, Vice Chairperson Rhodes and honorable members of the committee. I think in listening to the testimony today, we can all agree that we want to rid our state of dealers and suppliers, the big fish, so to speak, in the opioid supply chain. I want to, though, make a couple points. One, when I reviewed the bill as it's written, I noted what I consider to be an inconsistency. In Section 1, under the Controlled Act penalties, it cites 5 ounces or more of a mixture or substance containing any of the following, including adulterants or dilutants: A, cocoa leaves, except cocoa leaves and extracts of cocoa leaves from which cocaine, ecgonine, and derivatives of ecgonine or other salts have been removed; or B, cocaine other than crack cocaine, its salts, optical and geometric isomers, and salts of isomers; C, ecgonine, its derivatives, or salts, isomers, and salts of isomers. Then it goes on to spell out the amount, or the threshold amount for lysergic acid diethylamide, which is LSD, and PCP. And then it talks about heroin, or it describes heroin, its analog, crack cocaine, which for the record is a mistake. Crack cocaine obviously is not an analog of crack cocaine, of fentanyl, excuse me. But I wanted to call to the attention that in my experience in the substance use treatment world for the past 2 decades, I've never known anyone who consumes 5 ounces of cocaine and survives. I know a lot of cocaine addicts, but that is an extreme amount that would suggest it comes from a direct dealer. I would ask you to compare that to the amount of fentanyl that's cited here, which is 5 grams. And I understand the testimony that 5 grams might be as much as 200 to 250 lethal doses, but the scientific literature is replete with how quickly an individual becomes addicted and dependent physically on opioids. It occurs for some people in a matter of days, but for everyone else in a matter of 2 or 3 weeks. They escalate the dose. The people using 5 grams are not dealers. These are people like you and me, people who might have been prescribed Percocet or Dilaudid for a pain problem from their PCP, and then went on to somehow access illegal opioids. So I ask you to consider that there's a bifurcation in this law, that we're looking, one, at quantities, and then we're looking at penalties. And I would suggest to this committee to please, if we're going to keep this legislation, to at the very least increase the amount in fentanyl of it and its analogs to at least what is cited in cocaine, which is 5 ounces. 5 ounces is 120 grams. And for the record, on my earlier testimony, I talked to Representative Pratt earlier. The statistic I cited was 32.3 deaths per 100,000 in New Hampshire when I was describing overdose deaths. And I'll also state that any overdose death is too many. But I would ask that we look at the amount here, because if we keep it at 5 grams, we're going to incarcerate a whole lot of citizens who are like you and me, who shouldn't be in jail, who are going to cost us in excess of hundreds, if not millions of dollars in prison and jail costs. And I think it's also important, as John Burns described earlier, to remember the human in this equation. This is not the stereotypical, quote, junkie, unquote, on the side of the street living homelessly. These are people like you and me who are going to suffer the consequences. They already are suffering the consequences. There's no one that I've come across in my 20-year career in the substance use addiction treatment field when I've asked them this question: hey, did you want to grow up to become an alcohol or addict, that's responded affirmatively? When someone is an addict, volition goes out the window. There's no longer a choice to use the substance. And I think that point really needs to resonate with this committee. People who are actively using no longer have a choice. There is treatment available. There are modalities, including harm reduction, peer support services, medication-assisted treatment, but the choice goes out the window. So instead of putting people who otherwise have led sterling lives but have an intractable substance use disorder in jail, please consider the consequences, at least with the amounts cited for fentanyl and its analogs. And again, I would respectfully request that the committee oppose mandatory sentencing minimums, which we know from the data has done nothing to keep our communities safer. Thank you.
Mr. Are you okay to take a question from the committee?
Yeah.
Representative Newman?
Yeah, based on your comment about how the amount should be increased, do you have any comment about the including any adulterants and dilutants, since it seems like we can't tell very well what the quantity of actual fentanyl is in there?
That's a very pertinent question. I think it's, as far as we're concerned, at the street level, what's being sold for fentanyl is believed to be fentanyl. So if the entire substance, including adulterants, is 120 grams, I would be okay with that in the legislation.
Thank you.
Thank you very much.
Dr. Hannon?
Good afternoon, members of the committee. My name is Joe Hannon, and I stand in opposition to SB 415. I'm not going to repeat all the things that I've heard that I absolutely agree with. I think it's an egregious, dangerous thing, but there were a couple little points that I thought of as other people were speaking that I thought I'd draw your attention to. You know, the idea that just because someone has an amount that is a lethal amount or more than the average user amount, I mean, we only look at that in terms of drugs. You can buy a truckload of alcohol at the state liquor stores. You can buy 20 cartons of cigarettes. It's totally legal. These are very dangerous amounts to have, but people don't do that just because they're dealing. I mean, during COVID, I mean, I'm sure I'm not alone. People out here ran out and bought toilet paper. I still have some left because I'm not a toilet paper dealer. I bought what I thought would be enough to get me through the crisis. Now, people that are homeless or people that are not homeless, who have a job, who are working and using illicit substances, they may buy larger quantities to get through longer periods of time. I have to drive 30 minutes to get to the dentist and 25 minutes to get a haircut in this state. You know, so, and I have a car. You know, what if someone doesn't? It's very difficult if you're living in a camp somewhere or in a shelter. It's very difficult for people to go to do that on a regular basis. And the idea that even touching it is lethal and dangerous, it is a myth. It has been debunked numerous times by medical professionals, and it is completely false. Even if you use a fentanyl patch, which is the designed method of transporting it through the skin transdermally, if I put a fentanyl patch, put 10 of them on my arm and sat here for 5-10 minutes, I probably wouldn't even get that much of an effect from it after a few minutes. You have to leave it on for hours, even with many hours, several hours to get the effect. It's a slow release thing. If you put it on your skin, it doesn't go through your skin, period. It does not happen. So every time you've seen an incident of a police officer who was, you know, they touched their hand and they fell down, they've never found fentanyl in their systems when they've drug tested them or checked them for anything else. It's usually a fainting reaction or someone who's been so scared. The reason why I bring this up is important is it doesn't pertain directly to the bill, but I think it goes to the stigmatizing effect that legislation like this has and the conversations that go on around drug use. When someone is scared of even touching fentanyl for fear of death, the chance of someone surviving a drug overdose because someone is scared that they may touch fentanyl if they go near that person or do mouth to mouth or even touch their skin, they're afraid to do that. If they're afraid, the longer it takes the longer you wait to reverse an overdose, the more dangerous and lethal that becomes. So we don't want people to be afraid. I'm not saying you should go around and just smear it all over your body. It's probably not, financially advisable, at least. But I think that it's dangerous to have these talks that it's so bad that we have to take these people and they have to mandatorily do the sentence, regardless of the circumstances. There's very few things we do this with. If we do this, we'll have people serving more time than if they committed manslaughter or vehicular homicide in some places. This is not something that we want to go down that road. It's a sledgehammer for prosecutors. This is my last point. We're taking that power, like you've heard, away from the judicial branch and giving it to the executive branch. The prosecutors can now use this to coerce people to take a deal. And we know that most people don't even go to trial. Most people that get prosecuted take a plea deal. If everyone that took a plea deal, everyone that got prosecuted took a plea deal, did not take a plea deal and decided on a jury trial, our system would shut down because we don't have the resources for everyone to go to trial. But when someone takes a plea deal, they may not even be guilty in some instances. They're just afraid of having, I could do 40, 90 days or 6 months for what I might have done. But now they're throwing this potential mandatory minimum charge, and I'm going to have to go to jail for a mandatory sentence. And they just take a plea. Now, some may say that's in the interest of justice, but we're taking someone who may have been able to get out on something easier and had a better life. Also, the longer someone's incarcerated, incarceration is criminogenic, if I'm saying that correctly. The longer someone's in jail, the more likely they are to live a life of crime. People that are in for 10, 20 years, they don't just get out and start teaching school and Sunday school and doing community service all the time. That's not the norm. It happens, but it's not the norm. And the last part of that, when the prosecutors coerce people into taking plea deals, they oftentimes coerce, and this is the main rationale I've heard from law enforcement I've spoken to is, well, we want to get the next person up the ladder. So we can use this as a plea or a tool to coerce either a plea bargain or to get someone higher up the chain. And that's not always what happens. But I can tell you firsthand experience, not firsthand, secondhand experience, sorry. When I was a state rep, I had more than one person come to me and say they were forced to be a criminal informant. Otherwise, they had to do these 7, 15-year sentences, and they were scared to death. I had someone who worked for me who's had a friend who was in this position, and they were scared to death because they were not just asked to, tell on, to tell on their partners or the person they bought the drug. They wanted someone really high up the chain, and they kept using this person and using them. Now you're putting someone in a very dangerous position. We want to get the big fish, apparently. I guess no one's saying that's not a good idea, but we're putting people in danger by doing that. And this is a tool that can make that a more of a bludgeon for a prosecutor or law enforcement to use to go after people who are maybe low-level offenders who are really just harming themselves, but now we're putting their lives in jeopardy by making them testify against someone who may be more dangerous and lethal. And also drug dealers, like if you lock them all up, there'll be more. We don't have a shortage of dealers. It's actually every time one gets arrested, all you're doing is creating a job opportunity for the next person to move into that area. So, crime's going to go up. It did in Florida. Crime went up almost 50% in Florida after they instituted mandatory minimums way back. So there's no data to support this, and there's plenty of data to show that this is a bad idea. So I ask you to please vote this inexpedient to legislate. We're good? All right.
Apparently, we're not good. Representative Newman?
Yeah, I just
He's
have a
good.
question about distribute. My definition of that is just pass around, and it's not more complicated than that. I'm wondering what you might say to that.
I mean, distribution. I mean, you're well aware of this being, it's there's a difference between actually selling it and intent to distribute. There's laws in the books that say if it's over this amount, then we have an intent to distribute, charge. But there are people who buy for other people and buy for groups of people. Anyone in here who's ever, shown up to a party with a bottle of liquor, if you drank the whole thing, you'd probably be sick, might have to get your stomach pumped. That doesn't make you a dealer. Are you giving it out? I have a friend who has a daughter who is in jail still to this day because she bought substance, and I believe it was fentanyl or something related to heroin back then. And she was using it with her boyfriend. They both overdosed, and he happened to die. She bought it and was just sharing it with the person that gave her, whatever amount the money was, a few bucks. And because she survived and bought it, she got charged with the, death resulting, and she had a long sentence, and she was a victim in a sense. If he bought it, it didn't matter who bought it. They both pooled their money. If you give me $20 and, I take my $20 and I buy something, I give it to you. Is it my fault that something happened to you? It's only a matter of circumstance that I happen to be the one who went and got it. And if that's what we're trying to prevent, we're not stopping the big level dealers. Most people that are selling on the street in New Hampshire are users themselves that are supporting their habit best they can. I mean, I did it in college. I was poor and I wanted Chinese food, so I ordered a combination platter every Thursday and ordered 10 egg rolls, and I'd sell the egg rolls on my floor in the dorm, paid for my meal. And people with the two drugs do very similar things. It's not unheard of.
Thank you.
Sure.
Guess we're all having Chinese for dinner tonight.
I am hungry. Sorry I brought that up this late in the day.
No more. Thank you.
All right. I don't have any egg rolls, but I have toilet paper if anyone wants to talk to me after.
Is there anybody here that would like to testify on Senate Bill 415 that has not turned in a card? Seeing none, we will close the public hearing for Senate Bill 415. And one more people, stay with me. We will open the public hearing for Senate Bill 316, and I believe yeah. Senator Abbas will introduce his legislation for us, or somebody's legislation. I'm not really sure whose. Yep, it's his. Did you just missed us? You know that's really what this is.
Good afternoon, everyone. Senator Daryl Abbas. I represent District 22, serving the communities of Pelham, Salem, Exton, and Plastow. And I am here to introduce Senate Bill 316, which, by the way, I don't want to take too much credit for this bill. So I know a very wise man actually wrote this bill, the chair of this committee. He wrote it last term and it didn't actually make it out of the House. So I'm hoping some better luck this year. The chair's not here today. But this has to do with possession of intent to distribute fentanyl class drugs with the intent to distribute when you import it into the state of New Hampshire. And speaking in general terms about fentanyl, I hear a lot about people's perception of what's going on out there. I guess for someone who's worked with criminals on the ground level, some want to get better, some are trying, some are not. And the person that buys drugs and then sells to their friends to, support their habit, they're making other people addicts, they're contributing to the problem. Do they have a disease? Sure. But they're doing anything to help themselves? No. And they're making it worse for other people around them. And that they're contributing to that problem, they're funding the market, all that. Well, this fentanyl is not made in New Hampshire. It's not being made here. It's being brought here. People are bringing it here. So every person that's dying from a fentanyl overdose in this state, it's being brought into this state. So if you're going to bring it into this state with the intent to distribute, which can be established several ways, it's not just the quantity amount, it's how it's packaged. If you have scales on you, if you have a list of your customers, which would be a very smart thing to literally write down your criminal enterprise on paper, but trust me, it happens. If you have large quantities of cash, $500-700, but you don't have any proof of employment, these are ways that they establish intent to distribute. If you can sometimes have a smaller amount, but if it's packaged in, let's say, 30 different bags, that's one way to factor that in as well. So this is to deter people from bringing it into the state, because where I live, Salem, I am right next to the fentanyl hub of New England. And the fentanyl, they literally call the route from Lawrence up if you go through Lowell come into Merrimack, Heroin Highway. That's literally the nickname amongst the criminal enterprises. That's what they call it. What often was happening, and credit to the Rockingham County Sheriff's Department doing a good job with this, but for a while, drugs were coming from Haverhill, and they would say, hey, let's cut through New Hampshire. We won't be detected if we want to get to Lawrence or Lowell. Well, law enforcement, to their credit, has caught on to that. But that's what's happening. That is what we're dealing with here. So they're bringing it into the state. People are dying from it. And if you're going to do that, we're going to, again, adding it all on. And I hear a lot of sympathy for the drug addicts. No, and I think a part of the problem is you got to hold people accountable for their behavior. There is resources out there to deal with substance abuse. There's several resources, all right? untreated. But if you're going to be distributing drugs to other people, no sympathy for that. That's why people are dying. And if you can import them into the state, you're contributing to the problem. And you're certainly not doing anything to help yourself. So having a strict penalty, guess what? Criminals do know when they cross over a border into a different jurisdiction that the penalties are different. Heck, we all do that with our firearms. We know if we go to other states what we're going to deal with. So I think we can hold people accountable for what they're doing. And there needs to be accountability. Without accountability for this, we're not going to get through this this opioid crisis anytime soon. So I'll take any questions, but please support Ought to Pass.
Representative Knoll. I wasn't laughing at
It's
you.
all
Please
good.
don't think that I was.
Laugh with me. Thank you, Madam Chairman. And thank you for taking my question. It's a little bit of a repeat. It rhymes. It's ubiquitous. I mean, it's in so many different things. And what this says is any person who enters the state while possessing any quantity of a fentanyl class drug. I mean, it could be so many different things. I wonder, is that what you meant? Like anything?
So, listen, possession with intent. I know the last testimony from the last bill, someone said you have to have a certain amount to have possession with intent. I don't like to yell from the audience, but that was an incorrect statement of law. There is no quantity amount that would invoke the intent to distribute. It's just one of many factors. And that's the existing law already with possession with intent. So this has to do with when you also import the fentanyl class drug into the state, because we know that they're not making fentanyl in the state. So could you have less than 4 grams or less than 3 grams? Yes. But if you have, let's say, $2,000 in cash on you, you have a scales on you. These are if it's packaged in a bunch of different small bags. So if you're 3,000 lethal doses of fentanyl that some people believe apparently is just for an addict's individual use. Well, if it's individually bagged into single doses, that's usually another sign of distribution. That's well known. I mean, expert witnesses have testified to that in court as proving possession with intent. So the actual quantity of the drug is just one factor. Obviously, having a lower dose makes it much harder to prove. But when it says any dose, that's the existing law, and that's pretty consistent throughout other states as well.
Quick follow-up. So what I'm thinking about is, okay, so if you were coming in, all of those other factors were intact, right? You had things bagged, apportioned, however, you had a large quantity of cash or whatever things I could think of other reasons for.
It's
but
large
okay.
quantities
But-
of cash without proof of employment. It's usually they give away.
Okay. Thank you. But I guess what my question is it could be in something that you think is something else, but then when the police test it, you could see that there was fentanyl in it. So that any quantity of fentanyl in something that you may have had no idea had fentanyl in it in the first place. So there may not be a mandatory minimum of 5 years for you bringing something else in, but come to find out it's got fentanyl in it, which most things do, and then it's a mandatory minimum, and you had no idea that was in there.
So claiming ignorance because what you thought was heroin turned out to be fentanyl, or your cocaine was laced with fentanyl, I guess if that's going to be the defense, it's still possession with intent. So they're still going to face a pretty tough charge. I guess my point is I've been hearing a lot of excuses for people who are in possession of a large amount of drugs and now importing them and doing all this stuff. And I'm not hearing anything about how to hold people accountable. I've been listening to it all the whole time, and I'm just pointing it out. I understand there's the treatment side. I understand that people, if someone buys, $100 worth of a drug and they go from Lawrence into New Hampshire, I understand that maybe you may think that's a harsh penalty, but again, they're bringing this lethal drug into the state. It's unlikely that that's going to be possession with intent unless they have the money, the scale. There has to be much more to it because the high burden of proof, very difficult to prove if they just have a few bags of something. If it's when they have drugs for beyond individual use that you can imply that on the amount that they have. So I've seen it happen several times, and I've had people charged with these offenses. They're difficult to prove the possession with intent, even when they do have the individual bags and the money.
Thank you.
Representative Muse?
So as I read our current statute, it looks like you can be prosecuted simply for transporting fentanyl within the state, regardless of whether or not you're transporting it across state lines. So, and I also understand, just reading our current statute, that you can be sentenced for up to 30 years for doing that. So what I'm not understanding is how we're making people any more accountable by passing this bill than they already are under our current law.
I can answer that for you. Different context. I had someone who lived in Worcester County, came all the way to Essex County to just rob a few cars, and trying to understand my knowledge of the criminal underworld as I do my job. Why would you drive that far away? I mean, you came all the, well, they didn't want to get ID'd. That was their answer. I said, well, you're getting awfully close to New Hampshire. How come you didn't come up here? And their answer was, well, the penalties up there, one, breaking into people's property, not as ill-advised in New Hampshire based on some of the stand your ground laws. Also, the type of penalty they would face was much harsher. That's coming from someone who's breaking the law in another state. So if someone's going to be transporting fentanyl and engaging in all this activity, we can't control what happens in other states. We can control what happens here. They know. And when dealers are transporting throughout New England, there was a time when the advice that would go out there was to not stop when you're traveling through New Hampshire. That was before our bail reform, because they won't just keep on going. Those were normally the orders of the people who are trafficking drugs throughout the area. So if you're going to import drugs into this state, that's what we're trying to deter. That message will be known in the criminal under. Trust me, they will know. I'm telling you that will act as a deterrent. Massachusetts right now, if you have a large capacity firearm that has a magazine full, it's without a license, it's 18 months mandatory sentence. If all the people don't like mandatory sentences, reach out to that state. But the firearm, and it's 18 months on top of that for just the magazine. I live right on the border. I know very well not to bring that firearm into that state. I travel quite frequently. They have my offices located there because that's the law, and I respect it, the law when I'm in, when in Rome. So we're asking people to do the same here.
Senator, if I may ask a question. So if you could put on your employer hat for a second. I don't remember the person that testified to it, but there was a comment that was made about when the police come, everybody's running, right? They're taking off.
Which, by the way, is also can be a crime of resisting arrest. So I would, whoever recommended that, very ill-advised.
Well, I've never run from the cops, but that's not the point. So my question is this: if that comment was made about, generally speaking, you see the cops and you're booking it,
and I'm the one out of touch, right?
Why would the person be booking it when they see the cops?
Not recommended. They either, quite often they have a warrant out. Sometimes, believe it or not, the cops and people who are involved in the drug trade, it's not always their first interaction together. They tend to recognize each other, especially in some communities, which, you'll see that in the police reports, why they're following the person in the first place. So-and-so's a known trafficker, and they will cite in the report about the previous arrest they had involving drug trafficking with this individual. When they're on patrol, when the drug task force doing their thing, they see it. And then when they go to stop the person runs. So quite often they run and then try to throw whatever they have on them. And by the way, that does destroy any search and seizure argument.
Thank you.
And I just clarify, it was not a recommendation. It was just an offering of what they observed happening, that running from the police.
Well, it's recorded on video, so we can play it back.
I'll be happy to.
Thank you, Senator.
Thank you. Please support ought to pass. Thank you.
Mr. Curiel?
My name is Dominic Curiel. I'm a second-year law student at UNH Franklin Pierce School of Law. I have a criminal justice degree from San Diego State University. And today I'm requesting that the committee amend SB 316 simply by adding the word knowingly in front of transports. I think you'll find that my experience living in Southern California and my legal background, my legal training has prepared me to spot out this slight, I guess you could say, inadequacy of the bill, with all due respect for the makers of the bill. But the word knowingly appears nowhere in the bill. And from my experience, I had a coworker who was offered around $5,000 to drive a car, basically, just from just across the Mexican border. That's all he was told, is you're going to drive this car. And in fact, that's what these cartels have been doing for years. They've been outfitting cars with hidden compartments. And I've actually included just an article in my written testimony. They outfit these cars with these compartments, and they hire people on the American side of the border because it would be suspicious to hire a Mexican national to drive into America. And the money is too good to turn down. It's an incredible amount of money for somebody who may be struggling, and it's an easy job. So I'm not here to argue over mandatory minimums today. I think this is a tidal wave that has momentum. I want to use my training from UNH Law School to protect criminal defendants, and this would protect criminal defendants. There's a legal concept called mens rea, which translates to mental state. Each criminal statute has a mental state. If there's none, the court may read in a mental state. However, I want to save the state time and money. I don't want to see the state. I don't want to see another one of these cases in my textbooks. I see it all the time, and this reminded me of a case I read in criminal law. So to avoid unnecessary litigation, let's just add in the word knowingly. It's a big change, but it's a level of culpability New Hampshire recognizes as linked in my written testimony. New Hampshire NH Rev Stat and 626 :2 in my conclusion describes level of culpability in New Hampshire, and it actually alludes to attaching a mental state, a mens rea, to each material element of the offense. And as you know, transporting is a material element of this offense. So we are in the middle of an opioid epidemic, and I can tell you firsthand that the reason we've gotten to this place is fentanyl, and the reason that cartels are producing it at an extraordinary rate is it's easy to produce. You can produce it in a house, whereas cocaine requires just an enormously large field of coca leaves. And sometimes the Mexican government will burn down these crops. And so these cartels are getting experience from Chinese chemists coming across the border, teaching them how to make these drugs. and they're making it in houses. They're called finiqueras. And I just would like to see any criminal defendant hired without the knowledge of transporting what they're transporting. I know it seems ridiculous that you wouldn't know what you're transporting, but this is sort of adding an additional layer to the intent to distribute. So if the state was to find scales and baggies, as the former speaker referred to, that could show intent, and actually criminal history could be can be used against a criminal defendant to show propensity to commit a crime. So I would like to protect the people by adding this mental mens rea in front of the word transporting. Thank you very much, and I'm open to answering any questions.
Representative Reed.
Thank you, Madam Chair. My first thought about this mens rea is if somebody approached me and said, would you drive this car across the border for $5,000, I think that would trigger a red flag.
Yeah, of course.
You know, it's just ridiculous to not know something's off with that. And how would you prove now a mens rea, or now somebody had knowledge of what they were doing, if their go-to default would be, I didn't know.
Yeah, right.
So I don't know. I think that's kind of a stretch, but if you could, elaborate a little.
Of course. Thank you very much for the question. Would a court, now I'm a second year law student. I'm set up to work with the district attorney this summer, so I don't really know the ins and outs, but I did look up knowingly in the New Hampshire statute and the criminal code, and it's a subjective standard. So the prosecution would just inquire exactly what you just said. What did you what did you know? It's a very subjective test. So people wouldn't just be able to say, "Oh, I didn't know," because a good prosecutor will ask questions. Will say, "What questions did you ask? How did you not know?" This is exactly, and to be clear, I am totally. I'm for putting people in jail if they knowingly distribute or transport, and I'm even more for having these people be accountable for asking questions and not playing dumb. And I don't think playing dumb would, by adding this word in front of transports, it would not allow a criminal defendant to play dumb, in my view. I think it's a great bill. I really do, and I really do. I really appreciate this bill. And at first I had, well, I'll just move on to.
See no more questions. Thank you very much.
Thank you.
Claire? I thought you might.
Good afternoon, community members. My name is Claire Biche. I am also a second-year law student at UNH Law here in Concord. I'm very passionate about criminal law. I plan to go into criminal prosecution after graduation. So I do appear here today to support SB 316, just with a couple modifications. While I would support harsher penalties for the possession of fentanyl, a minimum of 5 years is a harsh price to pay without first setting a minimum quantity required before that sentence goes into effect. So under the current draft, even trace amounts of fentanyl will land someone in prison for 5 whole years. And mandatory minimums aren't new in New Hampshire, so I've provided 2 examples. One is RSA 651-2b, where there's a minimum sentence of 3 years for a subsequent or second offense of a felonious use of a firearm. So the second time that a felon uses a firearm is when a minimum sentence is used. And then also RSA 318B26(5). This will look a little familiar considering this is the RSA that's being amended in this bill. So only after a person manufactures, sells, dispenses, etc. in or around a school is a mandatory minimum imposed. And in this case, that minimum is only a year, and that's for exposing school-age children to any kind of drug. So in comparison to these examples, 5 years is a steep price to pay for even a first-time offense for any amount of fentanyl while entering the state of New Hampshire. Mandatory minimums also eliminate judicial discretion to impose a prison term lower than the statutory floor, making specific information about the offense or the offender irrelevant, at least to the extent that facts might call for a below minimum sentence. Historically, mandatory minimums have only burdened our criminal justice system by making people serve sentences that may not provide the correct deterrent effect for them. So I cited to a study sponsored by the U.S. Department of Justice that shows that mandatory minimum sentences do little or nothing to actually deter people from committing crimes. And that's an expensive risk to make when in 2021, I believe, the New Hampshire Department of Corrections estimated that the annual cost to keep someone in prison is $54,386. So in conclusion, I respectfully ask that the committee modify SB 316 to either lower the minimum sentence, require a certain amount of fentanyl before the minimum sentence is actually imposed, or provide exceptions or situations where judges can impose a reasonable sentence. Thank you.
Thank you, Ms. Bish. Are there any questions? Thank you very much. Mr. Lothstein?
Thank you so much. Again, Ted Lothstein here on behalf of the New Hampshire Association of Criminal Defense Lawyers. I think that everyone is here who was here when I testified earlier with respect to SB 414 in opposition to it. I'm not going to repeat any of that. That's why I didn't ask to speak with respect to the related bill, SB 415. The only reason I came up here is to express something that may be obvious to everyone in the committee. And if so, I apologize, but I'm only going to take up a minute or two of your time because it's late in the day. And it just feels so obvious. The other bills I'm just going to call well-intentioned but misguided. But this bill just seems completely broken. The people who go to Massachusetts to get drugs to bring them to New Hampshire are us. It's not methamphetamine. We can't make it ourselves in our kitchen. Just as the senator said, it all comes from somewhere else. So for every drug dealer in south of Salem, in Methuen or Haverhill or Lawrence, who drives across the border to sell, there's probably 5 to 10 New Hampshire residents who drive down to those cities to buy. And when they come back, now they're facing a mandatory minimum. Only because a mandatory minimum, 5 years, with no exceptions, even for a first offender, simply because they chose to buy their drugs in Lawrence instead of Salem, or in Newburyport instead of Hampton Beach. It's crazy. This doesn't make any sense at all, and I'm probably being a little intemperate in how I describe it, but that's what this bill would do. The result would be, if it has any deterrent effect at all, Massachusetts drug dealers would just set up more operations in New Hampshire. So they have the stuff here and they're selling it here, so that they're unlikely to be caught transporting it across the border. This does not make any sense. All the drugs are coming from elsewhere. Our own citizens who are sick with addiction are going across the border to get it. We should not put them in prison for 5 years for driving that extra mile from Salem into Methuen or wherever they end up. And that's all I have to say.
Thank you very much. Are there any questions? Thank you very much.
Thank you.
Committee members, I will close the public hearing. Before everybody runs out, 2 things. If you could just please join me in wishing Karen a happy birthday today. Turn on your microphone. Tell her happy birthday. Oh yeah, I can't. Happy birthday, Karen. I think she's still in there listening to us.
Happy birthday, Karen.
And and before you all head out, hold on just one second. Brad, are our cameras off? Stay with me, people. One second. So I just want to let you guys know that I think Representative Geffright News might have been here today, but it looks like the Senate has put all of our bail bills into one giant bill. And in the
Finance.
I
It's
thought
the
the
House.
Senate did it.
No, it's the House Finance.